Mr. Chairman, the meeting is now live.
We're ready to reconvene and go back on the record for the agenda portion of our hearing. The first item, well, before I move on to that, I wanted to make sure that Mr. Moon, are you able to hear us?
Yes, I'm good.
Great. I apologize. I did not recognize that you were in attendance during the briefing session, but look forward to the next time you're able to be here. The first docketed item on the agenda is docket number 2021-013, cause number 138-02, in the matter of the request for agency action of CH4 Energy Findlay, Utah LLC, requesting that CH4 Energy Findlay, Utah LLC be designated as operator of the 1,280 acre drilling unit. I won't read any more of this because this matter has been dismissed without prejudice. So we'll move on to the next docketed item, which is docket number 2021-014, cause number 130-07, in the matter of the request for agency action of Oventive Production, Inc. for an partially vacating the board's order entered in causes number 139-8, 139-42, and 139-90, and modifying the board's order entered in cause number 139-160. I think at this time we would like to take appearances of counsel.
Fred McDonald on behalf of Oventive USA, Inc.
Coming in electronically.
Correct.
From the
Haley Souza for the Division of Oil, Gas, and Mining.
Thank you. I will turn the time over to you, Mr. McDonald.
Thank you, Mr. Chairman. With me today electronically from Oventive are Mr. Peter Burns, who's the Senior Land Negotiator. Peter, would you please wave so that they can identify you? Mr. Josh Reamer, who's the Geoscience Manager of Development for Oventive. Josh, thank you. And Mr. Byron Boulding, who's the Development Reservoir Engineering Manager. At this time, I would ask that these witnesses be sworn in.
Please, Michelle, could you take care of that?
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Chairman and members of the board, the resumes of all three witnesses were submitted collectively as Exhibit A in this matter. If separately asked, each would verify the contents of their resumes are true and correct. Mr. Burns will be a fact witness only today. Messrs. Reamer and Boulding were previously recognized by the board as experts in geology and reservoir engineering, respectively, in cause numbers 600-02 and 600-03 last year. And presuming the division has no objection, we request that they again be so recognized by the board for purposes of this cause.
Division, any objection?
No objections.
Board members? No objections, so they are recognized.
Thank you, Mr. Chairman. And also just to confirm, it's acceptable to move for admission of all of our exhibits at the end of my presentation in chief.
That is preferable. Thank you.
All right, thank you. Mr. Chairman and members of the board, first of all, as you would notice, I mentioned that I'm counsel now for Oventive USA, Inc. Effective July 1st of 2021, which was after the filing of this request, Oventive Production, Inc. merged into and is now known as Oventive USA, Inc. So when we refer to Oventive, we're referring to that entity. Oventive is before you today requesting partial vacation of older sectional Lower Green River Wasatch spacing orders, specifically the orders in cause numbers 139-8, 139-42, and 139-90, as pertaining to sections 1 and 2 of Township 4 South, Range 4 West, and instead, and as applicable to other lands that are currently unspaced, we're asking for the establishment of 1,280 acre drilling units comprised of various sections within 4 South, 3 and 4 West, for Lower Green River Wasatch wells, including conversion as was originally established under the board's order entered in cause number 139-134. The orientations of these drilling units will be varied. It'll either be stand up or vertical, which Mr. Reamer will address the geologic basis for, while Mr. Burns will address the practical land basis for those different orientations. In addition, Ovintiv is seeking modification of the board's order ended in cause number 139-160 to change the orientation of those already established 1,280 acre drilling units comprised of sections 5 through 8 of Township 4 South, 3 West, from stand up to lay down orientation for the same geologic and practical land reasons to be addressed by Messrs. Reamer and Burns. As some of the board members may recall, one of the major goals of the 139-160 order was to help delineate the proper drilling unit orientation for long lateral horizontal wells as the fracture orientation in this western portion of the Uinta Basin shifts from those from the eastern portion. However, due to the price crash and pandemic over the past year and a half, none of the long lateral wells authorized under the 139-160 order have been drilled yet. Ovintiv collectively refers to these lands as its Bridgeland Prospect. True and correct copies of the 139-134 and the 139-160 orders were collectively submitted as Exhibit B in this cause. As it has done in the past in previous hearings, specifically the hearings on cause number 139-150, 139-160, and 600-02, Ovintiv requests the board to take judicial notice of the testimony of Mr. Mike Jensen and the exhibits admitted into evidence in the 139-134 hearing pertaining to the concept of drilling unit conversion and how correlative rights in existing wells remain protected thereby pursuant to Utah Code Annotated Section 63G-4-206, subparagraph 1B4. Like the 139-134 order, Ovintiv does not seek overlapping drilling units for vertical, short lateral, and long lateral wells. Instead, Ovintiv is requesting that production from existing vertical, directionally drilled, and short lateral wells remain on a sectional drilling unit as to the lands currently spaced, or on a wellbore basis as to lands not currently spaced, until the first long lateral well is drilled, and then effective the first month following the date of first production, providing for the production from all wells to be allocated on the 1,280 acre drilling unit basis, which is otherwise referred to as conversion. This will prevent premature and unnecessary modification of existing rights to production until such time that the drilling of the first long lateral well on the requested drilling unit, and it also mandates such a modification. Ovintiv is requesting authorization to drill up to 12 long lateral horizontal wells and up to 8 vertical, directional, or short lateral horizontal wells per drilling unit. This is the same as established under the 139-160 order. Setbacks of 330 feet for heel toe and 560 feet for perpendicular from DSU boundaries are also requested consistent with the previous board orders, including the 139-160. This will ensure maximum recovery of resource from each drilling unit. Since Indian mineral lands are involved, communitization agreements are required, and the agencies, whether under federal guidelines or by practice, require a spacing order from the board for such communitization agreements to be approved. This is another reason that Ovintiv is before you today. The board has jurisdiction over this matter pursuant to Utah Code Annotated Sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners within the Bridgeland Prospect, to the working interest owners, including unleased owners, in established drilling units, or if unspaced, the quarter-quarter sections adjacent to the affected area due to the requested setbacks, and to the BIA and BLM, being the governmental agencies having oil and gas jurisdiction over many of the lands. The mailings were sent to these parties at their last addresses disclosed by the relevant agency and Duchesne County Realty records. Many were returned as undeliverable because of bad addresses as reflected in those records. The record will also reflect that notice was duly published in the Deseret News on July 2nd, the Salt Lake Tribune on July 4th, and in the Uinta Basin Standard on July 7th. A letter of support for the granting of Oventive's request was timely filed with the board secretary by WEM Uinta LLC and WEM Uinta 2 LLC, both working interest owners in the area. A second letter of support was filed with the board yesterday by CH4 Energy Findlay, Utah LLC, also a working interest owner. To the extent those letters are not already deemed part of the record, Oventive requests that they be admitted into evidence collectively as petitioners Exhibit R. The division elected not to file a staff memorandum in this cause, and no other objections or responses were received. With that, I'll commence my examination of Mr. Burns. Mr. Burns, would you please state your name and business address for the record?
Yes. Peter Burns, Oventive's address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And what is your current position with Oventive?
Senior land negotiator over the Uinta Basin area.
And in particular, the Bridgeland prospect?
Yes.
All right, would you please provide for the record the corporate and bonding status of Oventive?
Oventive is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal, Indian, and state agencies. It is the successor by name change to Newfield Production Company and merger of Oventive Production, Inc.
All right, I'm going to now start my PowerPoint presentation. Can everyone see that okay?
Yes.
Yep,
All right.
we can see it here.
Okay, Mr. Burns, I'm going to refer you to what have been marked as Exhibits C through I for purposes of this cause. Do you have those in front of you?
Yes.
And were they prepared by you or Oventive personnel with your input and review?
Yes.
Okay, directing your attention to what has been marked as Exhibit C, which is shown on the PowerPoint, would you please explain to the board what it represents?
Exhibit C is a regional locator map of the 6 DSUs we are seeking spacing on today. The 6 DSUs are shown in the red hatch. They're located approximately 4 miles east of Duchesne City along Highway 40.
All right, turning your attention now to Exhibit D, would you please explain to the board what this shows?
Exhibit D is a status of the existing spacing orders in the general vicinity in the Uinta Basin. Sections 5 through 8 of 4 South 3 West are currently subject to the 139-160 order, which created 1,280 acre spacing for stand-up drilling units with conversion. Sections 1 and 2 of 4 South 4 West are currently subject to the 139-8, 139-42, and 139-90 orders, creating sectional drilling units for vertical, directionally drilled, and short lateral horizontal wells. Currently, no spacing for long lateral horizontal wells exists here. Section 18 and 19 of 4 South 3 West and sections 11 through 13 and 24 of 4 South 4 West are currently not subject to any board spacing order. Therefore, only the general well siting rule currently applies. All of Oventive's other spacing orders, such as 139-134 and 139-160, provide for conversion and not overlapping DSUs for vertical, directional drilled, or short lateral horizontal wells, as reflected in this exhibit on the lower left-hand corner. Oventive's preferred approach is conversion, as was addressed in Mr. Jensen's previous testimony, of which the board has taken judicial notice.
Okay, now turning your attention to Exhibit E, would you please outline what this represents?
Exhibit E is a zoomed-in view of the 6 DSUs we're seeking to space with the 3 existing wells in these particular sections. There's 1 directionally drilled well in section 6. Production currently allocated on a sectional basis pursuant to the 139-160 order. previously subject to a compulsory pooling order in cause number 139-121. Full recoupment has not yet occurred. However, pursuant to finding of facts number 20 and order number 12 of the 139-160 order, Oventive will waive further recoupment upon the first of the month following the date of first production of the first drilled long lateral horizontal well to allow conversion to occur, and the previous non-consenting owners will participate on a go-forward basis. Important to note that no objections to this process were received either in the 139-160 hearing or in this case. There's also one vertical well in section 2, production currently allocated on a sectional basis pursuant to the 139-8, 139-42, and 139-90 orders. There are no non-consenting parties. Lastly, there's one short lateral horizontal well in section 11. All mineral interests are leased and voluntarily pooled, less than except one owner of a small interest. Oventive has elected to carry her interest at 100% cost. Payout has not yet occurred, but upon the first of the month following the date of first production for the first long lateral horizontal well, Oventive will waive any remaining recoupment so conversion can occur, and the owner will participate on a go-forward basis similar to that outlined above. Again, there was no objection to this process received in this cause. And finally, consistent with the 139-134 and 139-160 orders, conversion of production allocation to the 1,280 acre DSU basis, presuming this RAA is granted, will be effective as of the first of the month following date of first production of the first long lateral drilled on the DSU, inclusive of the particular existing well, and effective as of the date of first production for the long lateral well. However, requested setbacks for horizontal wells are to be effective immediately.
Okay, turning your attention now to what has been marked as Exhibit F. Would you please outline to the board what this shows?
This is Oventive's current working interest across these particular DSUs, along with the unleased mineral interest and partner working interest shown. Oventive is the majority working interest owner in 3 of the DSUs, and with the support of WIM Uinta LLC, WIM Uinta 2 LLC, and CH4 Energy Finley Utah LLC, a majority of the working interest in the remaining 3 DSUs support the requested spacing and drilling orientation.
Turning your attention now to what has been marked as Exhibit G. Would you please explain to the board what this shows?
Yes, this is a map showing 2 of the DSUs which contain tribal minerals and thus will require a communitization agreement. Sections 5 and 6 and sections 1 and 2 each contain Indian mineral lands. It's our experience when Indian minerals are involved, a spacing order not only facilitates but is required for BLM and or BIA approval of a conforming communitization agreement, whether by guidelines or actual agency practice.
Now turning your attention to what has been marked as Exhibit H. Would you please explain to the board what this shows?
Yes, this is a topographic map of our proposed multi-well pad and layout for the 4 laydown DSUs. And my colleague will go through the geologic reasons for this shift. But the 4 laydown DSUs will be drilled from a single surface pad, minimizing surface disturbance, including road access and pipeline. The pad is also immediately adjacent to electrical power. And there are other topographic constraints, as you can see, with the Duchesne River and also wetlands associated with the river and rugged terrain in this area.
And again, these are the practical land reasons for the request shift from a stand-up under the 139-160 order to a laydown. Is that correct?
Yes.
Okay, would you please outline for the board, what are the current certification practices by Oventive under the standard orders that are out there on these long lateral wells What do you do when you have an off-site drilling unit? Excuse me, drilling pad.
Currently, Oventive certifies to the division that the horizontal well bores will be cemented and cased to the productive intervals within the established setbacks. Oventive also certifies to the division that we have obtained all required surface and subsurface consents and authorizations for the off-drilling unit surface hole location to drill through to drilling unit boundary when it's applicable. And these are required under both the 139-134 and 139-160 orders. Oventive has requested the same process be adopted here.
Now, turning your attention to what has been marked as Exhibit I, would you please explain to the board what this shows?
Yes, Exhibit I is an illustration to reflect how notice was provided. The areas within the red line are all production. We provided notice to all production interest owners. They all received a copy of the RAA. The blue areas, which did not show up on the map here, all working interest owners, including unleased owners in the established drilling units, and adjacent unspaced quarter sections adjacent to the area at issues. Those parties were all sent a copy of the RAA because of the requested setbacks, 330 heel toe and 560 perpendicular.
Okay, so just to clarify, instead of the blue areas, it's actually the solid lights
That were returned.
Yes, I believe some we were able to locate a better address, and those were remailed as required.
Mr. McDonald, can you go back to Exhibit F?
Certainly.
So this shows the working interest across the 1280s. What I'm unclear about is whether, and I only ask this because Oventive is requesting conversion as opposed to overlapping units. Does Oventive in each one of these sections, the 640 sections, does Oventive either by themselves or collectively with CH4 and WEM also have more than 50% ownership interest or working interest in each of the 640s that comprise these 1280 sections?
Yes, of these 6 DSUs, I would say that we do own collectively with WEM and CH4 support, we do own over 50% working interest.
Of the 6 DSUs, what I'm wanting to know is, do you own more than 50% of each of the 640s that comprise each of the DSUs?
Yes, I'm sorry, I should have been more clear, but on a sectional basis, we do own greater than 50% working interest.
Okay. So, Chairman Hanson, that's my last question.
Thank you. Any further questions from the division? Mr. Doucette?
Yeah, Dustin Doucette for the division. I have no questions. Thanks.
Okay, thank you. Board members, do you have questions of this witness? Hearing none, turn the time back over to you, Mr. McDonald.
Thank you, Mr. Chairman. With this, I'll commence my examination of Mr. Reamer. Mr. Reamer, would you please state your name and business address for the record?
Josh Reamer, business address is 4 Waterway Square, Suite 100, The Woodlands, Texas, 77380.
And what is your current position with Oventive?
I'm the Geoscience Manager of Development over the Rockies operating area with responsibility over the Bridgeland Prospect.
Okay, I'm going to refer you to what have been marked as Exhibits J through M for purposes of this cause. Do you have those in front of you?
Yes, sir.
Okay, and were they prepared by you or Oventive personnel with your input and review?
Yes, they were.
Okay, turning your attention to Exhibit J, which is shown on the PowerPoint presentation, would you please explain to the board what this represents?
Exhibit J shows the field type log, the Shell Brotherson 111B4 well, and highlighted in red is the application lands. This exhibit shows the stratigraphic definition of the Lower Green River Wasatch Transitional Formation, which comes from 139-134 and 139-160's orders. This exhibit also reflects the primary intervals which will be targeted in the Bridgeland Prospect.
Turning your attention now to what has been marked as Exhibit K, would you please explain to the board what this represents?
Exhibit K is a log of a well within the application lands, the U Tribal 11244W. It shows it's a correlative log of 5 primary targeted intervals for long lateral wells.
Turning your attention now to what has been marked as Exhibit L, would you please explain to the board what this represents?
Sure. This is a west to east cross-section through the area of interest. This highlights that the lower Green River Wasatch transitional formations constitute one common source of supply in the area, and is consistent with the board's designation of those formations as one pool throughout the Uinta Basin. It also reflects the uniformity and thickness across the area.
Turning your attention now to Exhibit M, would you please explain to the board what this represents?
Sure. Exhibit M is a map that shows the interpreted horizontal stress direction within the basin. In blue is the interpreted SH max, or principal horizontal stress. In blue and with arrows, you will see the input data points, which comes from either microseismic or FMI logs, which were used to generate the interpretation in blue. What you see in this diagram is that the average principal horizontal stress over the application lands is north 45 degrees west. For the 4 DSUs to the north, it is Oventa's request that we execute those wells as laydowns. And also from the reasons provided by Mr. Burns, why, from a surface perspective, why that's beneficial to us. For the 2 southern DSUs, we are applying for north-south or stand-up orientation. Again, you can see from the SH max interpretation, you're still crossing the SH max at a 45-degree angle. But one thing that needs to be highlighted here is the Duchesne fault zone, which is in brown. Oventa would like to intersect the Duchesne fault zone perpendicularly and try to connect up, if we see faults, as many faulted compartments as possible. This will ensure efficiency from a capital and even a fracture completion standpoint.
All right, so is it your expert opinion first that uniformity and thickness make the lower Green River Wasatch an attractive target for longer lateral horizontal drilling?
Yes, sir, I do.
Is it also your expert opinion that the fracture orientation supports both the laydown and stand-up units for the practical land considerations and the Duchesne fault reasons as you've outlined?
Yes, they do.
And finally, is it your expert opinion that the lower Green River Wasatch formations constitute one common source of supply?
It does.
Mr. Chairman, that concludes my examination. Mr. Reamer?
Thank you. Division?
I have no questions for Mr. Reamer. Mr. Doucette, do you happen to have any questions?
Yeah, a couple questions if I could. So on this exhibit here, you've got a pretty varied maximum stress direction, some closer to east-west, some closer to north-south. So is your interpretation the lands that are laid down to the north, do they more align with the more north-south fracture orientation on that polar strike plot?
Yes, sir, they do. If you can see from the 15 points that I provided here in this map, again, the blue rose diagrams that are on the map, there's a black orientation or a black arrow that's associated with that. So Dustin, you can really see which points is driving that interpretation. To the point you just made, most of those inputs to the north are almost north and south, if not a few degrees just to the west. So for the most part, yes, what's to the north would be better for laydowns, and then the transition happens as you begin to move south. And you see that most of the east-west orientations are more to the southeast.
Okay, thanks. I think that answers my questions. That's all I have.
Thank you.
Thank you. Board members, do you have questions for this witness? Seeing and hearing none. I appreciate that explanation you gave to Mr. Doucette. I was wondering that same thing. And I guess I do have a question. You feel fairly confident that, I'm sorry, I've got to increase the size of the picture so I can read the numbers. In sections 13 and 26?
24.
24, that the stand-up orientation will give you the best opportunity for production by intercepting the Duchesne fault zone.
Yes, I think it's our best method for execution. If the Duchesne fault zone was not there, hypothetically speaking, being a North 45 fracture orientation, you could drill it either which way you'd like, lay down or stand up. Because we do have this structural feature of the Duchesne fault zone, it is our opinion that we feel like we can get the best results by trying to execute perpendicularly against that fault zone. I think we'll have some frac efficiencies and try to connect as many compartments together as possible. If you did it east-west, potentially you could limit yourself from a frac orientation standpoint and frac half lengths. We don't want to do that. We think this would be the best way and to de-risk this area as much as possible.
Great, thank you. Just one other question, just from a geologic standpoint, do you have an idea of offset on these faults? And then, well, if you could just give me a guess what you think the offset is on these faults. Or are they strike slip, or are they normal?
So what we know about the Duchesne fault zone on the western side of the area, again, the Duchesne fault zone is a 40-mile long structural feature. What we know on the western side here is that we're probably more extensional faulting in nature. What we can see at surface is that you have grobens and half grobens. The throw across that's a very good question. Right now, we are trying to do our best to de-risk that and make sure we understand as we drill. We're going from up thrown to down thrown across it. If I would be making a full guess right now if we're going to see a number or a number of feet of throw. So I'm very hesitant to say that number. But we do know that this is a very complex area. We could have potential problems, but that's why we are trying to address it this way with the board.
Okay, thank you for indulging me on that. That was just purely for my own edification. Mr. Church, you have a question?
As a follow-up question on the fault zone. On the map, I assume those are surface traces that you have mapped of the Duchesne fault zone.
They are. They are.
And do you have seismic across it? Do you, with the stress and strains, is this a strike slip zone? Even though you see some grobens and up thrown or down thrown, with the stress, could you guess whether they were strike slips?
Yeah, so current day, the first question was, do we have seismic? The answer is yes. We are looking at that right now to understand our throw across it. The second question is this strike slip? Yes, this fault zone, we believe, has gone through a number of different stress orientations, from compressional to strike slip, and having some dextral or right-hand movement to it. So yes, it is very possible that there is transpressional events that have happened through this. So there could be some extensional throw, but there also could be some obliqueness that happened within that fault zone that's moving in that transpressional direction as well.
Thank you.
Well, one last question, if you'd indulge me, is do you anticipate, this may be a stupid question, but are you anticipating that these faults, having gone through different directions of stresses and strain, that the aperture along these faults, that there would be a little bit more of an opening in the fault zones themselves? I assume that's why you want to do the stand-ups, and that aperture is going to improve the transmissivity of the fluid moving through the formation. That's correct, right?
That is, you're highlighting a potential risk. Yes, of course it is. We're not 100% sure. This is a test area for us. That's why we would like to address it in this orientation at first, and we think we're going to learn a lot. And from these two test DSUs, we hopefully are going to use that going forward to develop the rest of the area.
Okay. Thank you.
You're welcome.
And I believe that's all the questions the board has, Mr.
I have a question, Chairman.
Oh, I'm sorry. Forgot you were there, Gordon. My apologies.
That in section 11, there's that well that is oriented north and south, and you're going to be drilling east and west through that area. Are you still going to be able to hit that zone that has that north-south well in it? And what will you do to mitigate risks there? Thank you.
Yeah, absolutely, Gordon. I think we can execute that. That zone was drilled in the Uteland Butte C. We're going to probably target below that. Luckily for us, Oventive that is, we have a lot of experience within the Bakken where we're used to drilling underneath wells that were diagonal and all different orientations. So we're pretty confident that, yeah, we can drill underneath it. We're very fortunate in Uinta Basin that the correlations while drilling have always been spot on. So I'm full confident that our team can get that done and drill underneath that well.
Thank you. One more question. Do you anticipate any more vertical or short horizontal wells in this spacing unit, or do you expect them all to be full 1280 2-mile horizontals?
Right now, we are proposing just 1280 horizontals. I can't speak about what the future brings, but right now, this is all we're offering.
Okay, thank you.
Yeah, you're welcome.
One more,
Thank you.
Chairman. I'm sorry.
Sure. Go ahead.
I do need to disclose that my family has a pretty good sized interest in this area, and extended family owns the surface also. So I need to disclose that and make sure no one has objections to me participating.
Thank you, Mr. Moon. That was going to be the next point of discussion. I was going to ask you if there was any interest and potential conflict. Thank you for declaring that. Mr. Begley, do you believe there's action or inaction?
Mr. McDonald, your client have an objection?
No objection on behalf of Oventive for Mr. Moon's participation.
That's satisfactory then.
Okay, thank you. Appreciate you doing that, Mr. Moon, and your advice, Mr. Begley. So we'll turn that back over to you, Mr. McDonald.
Thank you, Mr. Chairman. Commence my examination, Mr. Boulding. Mr. Boulding, would you please state your name and business address for the record?
My name is Byron Boulding. Business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas 77380.
And what's your current position with Oventive?
My current position is the Development Reservoir Engineering Manager over the Rockies, which includes the Bridgeland Prospect.
All right, I'm going to ask you to refer to what have been marked as exhibits N through Q. Do you have those in front of you?
Yes, sir.
Were they prepared by you or Oventive personnel with your input and review?
Yes.
Turning your attention now to exhibit N, would you please explain to the board what this represents?
So this is a very similar illustration, what we've shown in previous causes of our setbacks with our average frac half length in the Uteland Butte and Wasatch at 200 feet half length in the Uteland Butte and 334 in the Wasatch respectively. This orientation here is for a north-south stand-up DSU. So this would be the 2 southern DSUs in this spacing proposal. What we can see is with the requested setbacks of 560 feet and 330 heel toe, that we will not adversely affect correlative rights with the fractional orientation at 45 degrees here. And as Mr. Reamer showed, that is the average orientation across these subject lands. I think one thing.
Oh, go ahead.
One thing to note as well, and Mr. Reamer talked a little bit about de-risking this area and the lack of horizontal drilling under the current spacing order. At this time, Oventive is not requesting setback reductions until we gather more data in the area.
Now turning your attention to Exhibit O, please explain what this represents.
This is the exact same illustration, however, it's for the east-west laydowns, again with the same north 45-degree west fractional orientation. And here we are again showing that we will not adversely affect correlative rights.
Okay, and just for clarification, as you're aware, there's other operators that have asked for reductions from these 560 and 330 setbacks in other areas. I believe your testimony is that until you gather more data, that Ovintiv is not prepared at this time to ask for those reductions. Is that correct?
That is correct.
To take a more conservative approach for protection.
Yes.
Thank you. Turning your, however, though, if the data shows that reductions are appropriate, would you come back to the board and ask for those reductions as you develop the field?
Yes, we would.
Now turning your attention to Exhibit P, would you please explain to the board what this shows?
So Exhibit P shows our assessment of the 5 primary horizontal targets within the Green River to Wasatch formations. And if we were to develop up to 8 long lateral horizontal wells in each bench, what our respective recovery factor of that resource would be. However, at this time, we are only requesting the permission to drill up to 12 of these wells in the current cause number. So one thing we will note is if we do feel that more than 12 long lateral horizontal wells is required, we will come back and request that. Again, with that, there's adequate resource here to support the 12 long lateral horizontal wells, recovering about 2.3% of the estimated resource in place, with the addition of maintaining 8 vertical or short lateral horizontal wells that would recover an additional 1%. So a very reasonable 3% recovery factor.
Turning your attention now to Exhibit Q, would you please explain to the board what this shows?
So Exhibit Q is showing a simple type well, consistent with what we've shown for the area in the past at a $7 million well cost, a 582,000 MBO estimated recovery at a generally $50 oil price would generate a 22% rate of return and a 3.5-year payout. One thing to note is there are many factors going into this, obviously oil price volatility and market conditions, and all this just goes into our own company budget and how this competes within the Ovintiv portfolio, as these economics will be subject to those changing economic conditions.
So is it your expert opinion that up to 12 long lateral wells plus up to 8 vertical, directional, or short lateral wells are needed to drain each of the proposed drilling units efficiently and economically?
Yes.
Is it also your expert opinion that the requested setbacks and conversion should not result in adverse drainage and will be protective of correlative rights?
Yes.
Mr. Chairman, that concludes my examination. Mr. Boulding.
Thank you, Mr. McDonald. Ms. Souza?
I don't have any questions for Mr. Boulding. Does Mr. Doucette, do you have any questions for Mr. Boulding?
Yeah, a question or two if I could.
Please proceed.
Yeah, Fred, if you could go to maybe Exhibit N. So in this example, you're using the average max principal stress direction. So kind of based off of the previous testimony on Exhibit M and what your expected orientation in those different spacing units, how would that affect your distance from the setbacks from these section lines? I don't know if I stated that very well, if you understand the question.
Yes, I believe I do. If we're less, we're average 45-degree west here. If that were to turn more north south than what is shown here, obviously you would be approaching that section line. That is part of the reason why, with the lack of data in the area, we are not requesting those reduced setbacks. As if you were to go more east-west here, you would be further away from that 330 setback. So one thing, and then if we go back to Exhibit M, it might show it a little better, but the there is some uncertainty in the local data around these specific stand-up DSUs. We have a little more confidence as we go more towards the northwest of what that orientation is, but you can see there's right in the Duchesne Fault Zone, a little bit of an unknown. So that is part of the reason why we're taking a conservative approach on these setback requests. Does that answer your question?
Yeah, it does. Thank you. I don't have any further questions.
Thank you. Board members, do you have questions for this witness? Yes, Ms. Davis.
If you'd go back to Exhibit E, you've got a couple of wells in the lands that we're being asked to consider. And you're saying that to allow flexibility with respect to the drilling of vertical, directionally drilled or short length horizontal wells prior to the delivery of a long lateral horizontal well, and for the protection of correlative rights of the parties therein, Ovintiv requests that production from the subject formations from any new directionally drilled or short length horizontal well be allocated on a similar 640 acre drilling basis as under the 139-90 order. So what I'm asking is, are you going to keep that 640 drilling for the wells that are previously drilled to the long lateral horizontal, or are they going to be converted to 1280 drilling units?
Ms. Davis, if I can answer that, the situation is it remains on the 139.90 until the first long lateral horizontal well is drilled, and then it converts. That's the way that the request was drafted, and that's what Mr. Burns' testimony was as well.
Thank you.
I'm sorry, Ms. McDonald, drilled or first produced?
No, drill and first production.
Okay. Thank you. Any other question, board members?
Yeah, Mr. Chairman.
Yes, Mr. Moon.
So just as a mineral owner in this area, I would encourage the shortening the setbacks on, especially the heel toe, as soon as you have that data. And my question is, how do you tell after drilling the well how far those frac lengths and the orientation, will you have that after, say, the first well is drilled to know how much you can tighten up those setbacks?
So we are working through our plans for when we do drill in this area, what sort of data we can collect. Obviously, there is a cost to collecting additional data, but we do want to find out more information, in particular on the fractional orientation. So we are planning, certain logs to help us better understand that in this area. Based on those results, we'll look and see if there's any additional data we would need to collect to further our understanding of the fractional orientation in that area.
Yeah, because on your section line setbacks, I'm not as concerned because you can pick up that area, with lease line wells. But on your hill toe, it's kind of lost forever because you're never going to go back in and drill a well, to catch that difference. And so, yeah, I just encourage you to continue to look at that. And as a mineral owner, I would say I understand being conservative, so we're not encroaching on the nearby section. But that risk of just leaving that oil in the ground forever is, to me, a bigger concern than the possibility of a fracture, creeping across a section line. So just that comment. Thank you.
Thank you, Mr. Moon. Seeing no other questions for this witness, I guess we would turn the time back over to you, Mr. McDonald.
Thank you, Mr. Chairman. That concludes our presentation in chief. At this time, I would move for admission of exhibits A through Q, and to the extent necessary, the 2 letters of support as petitioner's exhibit R.
Okay, so admitted.
Also, I want to confirm that the board is going to take the judicial notice of the testimony and conversion as we requested.
Yes.
Thank you. With that, I'll just reserve time for some closing remarks after the division's presentation.
that would be fine. Sorry, I'm just doing a little paperwork here. The only other question I had for you, Mr. McDonald, is the division received a couple of letters related to this matter, as I recall.
I believe that's the other matter that's going to be heard next.
Okay, thank you. Thank you for that clarification. Well, I'll shut up and turn the time over to the division.
Thank you, Chairman. The division has not prepared a presentation for this cause because the division is generally supportive of granting the the relief requested. Thank you.
Okay. Thank you. Any further comments from the board before I go back to Mr. McDonald for his summation?
Just one quick comment. Is there any way, and this is maybe a question for Fred, is there any way we could include in this order that, based on, just to prevent Ovintiv from having to come back to make those setbacks smaller, is there any way we could include in this order, if there is data supporting shortening those setbacks, that Ovintiv is free within a certain tolerance to do that? Your thoughts?
It would be hard to incorporate that without the data and the evidence on the record to support that. Again, I think you have Ovintiv's commitment that if the data is shown, and of course this is a smaller, these are only 6 DSUs, as the rest of the area over there would be developed, that would be certainly part of the consideration for that. And as additional wells are drilled, for example, if they get enough data in the first well that's drilled in the DSU that it would show that a reduced setback is appropriate, then they could come back at that time for modification of this particular order to reduce those setbacks based on the data that they have. But my concern is with the record we have right now, that would be hard to incorporate in this to be able to do it outside of another board hearing.
Okay, thank you.
Thank you for that clarification. Well, we'll turn the time back over to you, Mr. McDonald.
Thank you, Mr. Chairman. Other than that, I believe Ovintiv has established and met its burden of proof. The statutory and regulatory requirements have been satisfied, and we would ask the board to approve the request as submitted. And we thank you for your time and attention.
Thank you. Board members, would you like to take a few minutes to discuss this issue? In the enthusiastic reply and blank stares that I'm getting, I would. So if we could take a few minutes, go off the record, and we'll deliberate on this for a few minutes and then come back. So Michelle, we're off the record. Thank you.
System check, system check. technical check. The board is still in private discussions. We're just conducting a technical check here. What? System check, system check. System check. We will be returning shortly.
Paul, are we ready to go? I'm sorry, I didn't hear you earlier.
Mr. Chairman, we are ready to proceed.
Okay. All right. Michelle, are you ready to go?
I'm ready.
Division, Ms. Souza, are you present? Not hearing anything out of the division. Mr. McDonald, can you hear me?
I am, Mr. Chairman. I'm here.
I can hear you now, Mr. Chairman. My apologies for the technical difficulties.
Great, thank you. We'll go back on the record. The board has deliberated and would like to move forward with the process. This has been an interesting one, but I'd like to turn the time over to board member Church.
Thank you, Mr. Chair. I'd first of all like to say this, I feel, is a very unique request to have horizontal offsets or horizontal spaced units immediately adjacent to vertically spaced units. And with this unique request, I think the circumstances also make it understandable, because with this structurally complex geologic area with the Duchesne Fault Zone, I think that can be demonstrated that the southern two drilling units are advantageously to be placed that way in order to intersect the fault zone, whereas further to the north, horizontal is in more agreement with these stress fields that are mapped. And so with it, I would like to make a motion at this time that the board approve this matter as has been requested by Oventive.
Is there a second?
I'll second that motion.
Discussion on the motion. The one thing I'd like to point out is there are no objections to this matter or for this request. So, normally I'd ask Julianne at this point to take a roll call vote, but I guess since we're almost all here, we'll just go along. All those in favor say aye.
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 Mr. Moon?
I'm an aye.
Thank you. It's unanimous. The motion is passed. Mr. McDonald, will you prepare the appropriate documents?
Certainly, Mr. Chairman. Thank you.
That concludes this matter. Now, we're just about at noon, so what we'll do is we'll go off the record, take our lunch break, and We'll come back at 1 o'clock and reconvene and go back on the record. Are you there? Mr. Moon? We lost Lavon Garrison. She had another matter she had to take care of, and I don't know if we've got Mr. Moon on yet or not. Any indication that he's with us, Paul?
We believe he has dropped off.
Do you want me to try and call him?
Hold on just a minute. Mike Begley is calling him right now.
Oh, okay, Gordon. No problem. I'm just checking on. We're about ready to start. Okay. You're almost on.
Okay. Mr. Moon, are you able to hear me? Not quite yet.
Okay, I'm here.
Ah, great. There you are. Well, we'll go back on the record and restart or start again with our board hearing. The next item on the agenda is docket number 2021-015, cause number 470-03. In the matter of the request for agency action of CH4 Finley Operating LLC for an order vacating the board's order and cause number 131-139, 2, modifying and extending the board's order and cause number 131-151, 2, and I'm not going to go through the rest of this. It's a matter of public. Besides, I'd screw it up anyway. So we'll take appearances of counsel for this matter.
Fred McDonald on behalf of CH4 Finley Operating LLC.
Thank you.
And Haley Souza on behalf of the Division of Oil, Gas, and Mining.
Thank you. Well, I will turn the time over to you, Mr. McDonald.
Thank you, Mr. Chairman. With me today via electronics is participation are Ms. Whitney Womack, is the landman for CH4 Energy Finley, Utah LLC. Whitney, would you wave to the camera so that the court reporter knows who you are? There you are. Thank you. Mr. Shay Atkins, who's the geology manager of Finley Resources, Inc. And Kayleen Tovar, who's the senior reservoir engineer of CH4 Energy Finley, Utah LLC. All three witnesses share duties with the petitioner. I would ask that they be sworn in as witnesses at this time.
Court reporter Michelle, could you swear them in, please?
Will you raise your right hands? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Chairman, the resumes of all the witnesses were collectively submitted as Exhibit A. If asked, each would confirm the information reflected in their respective resume is true and correct. Ms. Womack will be a fact witness only. Mr. Atkins has been previously recognized as an expert in geology by the board on several occasions, the last being in cause number 475-04 in March of this year. Presuming the division has no objection, we request that he again be so recognized for purposes of this cause.
Division?
No objections.
Ms. Tovar is testifying for the first time before the board, so we will qualify her as an expert in reservoir engineering at the commencement of her testimony. Again, Mr. Chairman, I just want to confirm it's acceptable to move for admission of our exhibits at the end of our presentation in chief.
Yes, thank you.
Mr. Chairman and members of the board, CH4 Finley Operating LLC is today seeking approval from the board of several measures which will allow for full, uniform, and consistent development of the Lower Green River Wasatch formations in Township 3 South, Range 1 East via long lateral horizontal wells. This will require the board to grant the following relief. First, the board will need to fully vacate its order in cause number 131-139, which authorized enhanced recovery operations in the Green River and Wasatch formations in sections 34 through 36 of Township 3 South, Range 1 East. Crescent Point, which was CH4 Energy Finley Utah's LLC predecessor in interest, was the petitioner in that cause, but it never initiated the enhanced recovery program. Instead, it sought development through long lateral horizontal wells pursuant to the board's order in cause number 131-151. The 131-151 order vacated the 131-139 order as to sections 35 and 36, but not as to section 34. And that's why we're requesting full vacation of the order today. True and correct copies of the 131-139 and 131-151 orders were collectively submitted as Exhibit B. Next, the board will need to modify and extend the 131-151 order to first establish stand-up drilling units comprised of sections 17 and 20, 27 and 34, and 29 and 32 of Township 3 South, Range 1 East. Crescent Point had initially omitted sections 17, 27, 32, and 34 as relating to long lateral horizontal wells, resulting in an off-pattern drilling unit situation. CH4's request will reestablish a uniform pattern for those drilling units. However, the existing drilling unit comprised of section 20 and 29 has 4 existing producing long lateral horizontal wells. To avoid interference with existing rights in those wells, CH4 is proposing to leave the allocation from those wells on its existing basis and only modify allocation to the requested drilling units for newly drilled long lateral horizontal wells. As Ms. Tovar will testify, interwell setbacks should prevent any communication between the existing wells and newly drilled wells. In addition, the board will need to modify the setbacks established under the 131-151 order from 330 feet to 100 feet on the north-south and from 560 feet to 330 feet east-west. While the board has previously authorized north-south setback reductions to 100 feet, this will be the first time that the board will address the reduction of the 560-foot east-west setbacks. Mr. Atkins and Ms. Tovar will provide the technical justification for those reductions. Finally, the board will need to establish overlapping 2,560-acre drilling units comprised of the 2 adjacent 1,280-acre drilling units to allow up to 6 drilling unit boundary wells, similar to what the board has previously authorized, including a 100-foot buffer on either side of the boundary line, and the requirement that 2 1,280-acre drilling units comprising the overlapping 2,560-acre drilling unit must each have a producing well upon them before a drilling unit boundary well may be drilled. The board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners and the requested drilling units, to all working interest owners, including unleased owners in the established drilling units, or if unspaced, the quarter-quarter sections adjacent to the requested drilling units due to the setback reductions, and to the Bureau of Indian Affairs, the Bureau of Land Management, and the School and Institutional Trust Lands, agency being the governmental agencies having the oil and gas jurisdiction over many of the lands. The mailings are sent to these parties at their last addresses disclosed by the relevant agency records, Uena County Realty records, and internal records of CH4 Finley Utah LLC. Many were returned as undeliverable as the addresses appearing of record were out of date. The record will also reflect notice was also duly published in the Deseret News on July 2nd, 2021, the Salt Lake Tribune on July 4th, 2021, and in the Uena Basin Standard and the Vernal Express on July 7th, 2021. The division timely submitted a staff technical memorandum in this cause, not necessarily objecting to CH4's request, but outlining concerns with the completeness of CH4's exhibits to allow an adequate level of technical understanding and scrutiny for the setback proposals. In response, and with production of confidentiality afforded under Rule R 649-2-11, subparagraph 4, and the Utah Governmental Records and Management Act, or GRAMA, CH4 did supply the division with the requested interpretive data necessary to hopefully alleviate the division's concerns and allow it to make a recommendation to the board today. The division also asked for a self-certification that the two 1,280-acre drilling units comprising an overlapping 2,560-acre drilling unit, boundary drilling unit, as being held by production be provided, and CH4 is willing to do so. In addition, an email dated July 14th, 2021 was received by the board from members of the Glynn family indicating they wanted to participate because they had questions. CH4 reached out to Kevin Glynn and presumably answered all of those questions. In addition, on July 23rd, 2021, John Adamson of Geo Opinion Inc. filed a letter with the board addressing concerns over the Section 20 and 29 existing drilling unit and future development. That letter was not received by myself or CH4 until this past Monday through the board secretary. However, according to CH4's records, Mr. Adamson and Geo Opinion Inc. do not own any interest in Sections 20 and 29, so we question his standing. Furthermore, his submittal was untimely and without a showing of good cause as to why it should be considered late. Finally, to the extent that he's Geo Opinion Inc., as opposed to Mr. Adamson individually, the rules require that he be represented by counsel. So at this time, we would object, with all due respect to Mr. Adamson, to his participation in this hearing. And if any statements are accepted by the board, they be given very little evidential weight. No other responses, and more importantly, no objections to CH4's request were received. With that, I'll start with my examination of Ms. Womack. Ms. Womack, would you please state your name and business address for the record?
Whitney Womack, 5128 Apache Plume Road, Suite 300, Fort Worth, Texas, 76109.
And what is your current position with CH4?
I'm a landman with supervision over the Ramlet area at issue.
Okay, would you provide to the board and for the record the corporate and bonding status of CH4 Finley Operating LLC?
CH4 Finley Operating LLC is a Delaware limited liability corporation in good standing with its principal place of business in Fort Worth, Texas. CH4 Finley Operating LLC is duly authorized to conduct business in the state of Utah and is fully bonded with all relevant state of Utah and federal agencies. It is the designated operator on behalf of CH4 Energy Finley Utah LLC.
All right, I'm going to start my PowerPoint presentation. Can everybody see that presentation?
We can see it here.
All right. Ms. Womack, I'm going to ask you to refer to what have been marked as Exhibits C through L for purposes of this hearing. Do you have those in front of you?
Yes, sir.
And were they prepared by you or CH4 Finley personnel with your input and review?
That is correct.
Okay, turning your attention to Exhibit C, which is on the PowerPoint, would you please explain to the board what it represents?
Sure. This is the regional locator map. It represents the area of interest or application lands that are shown in red. On the map, they're located directly south and southeast of Ballard City. The gold dashed lines are representing the overlapping drilling units in 3 South, 1 West, and 3 South, 2 East.
Now turning your attention to what has been marked as Exhibit D, would you please explain what this represents?
Yes, this is a plat of the subject lands of 3 South, 1 East with highlights of the requested overlap drilling unit boundaries well DSUs in 3 South, 1 West, and 3 South, 2 East that are hatched in gold. This also reflects the existing wells.
Now turning your attention to what has been marked as Exhibit E, would you please explain to the board what this shows?
Yes. This is a plat of the status of existing spacing orders on the subject lands. The solid green on the plat represents the 131, 151 order, which creates the 1280 acre DSUs for long lateral wells. The green hashed area is also reflecting the 131, 151 order, but only as to overlapping vertical and short lateral horizontal wells. These sections were omitted as to long lateral wells leading to the off-pattern DSUs as shown. The blue color in section 34 is the remnant of the 131, 139 order, which is the enhanced recovery project proposed by Crescent Point, CH4 Finley's predecessor in interest, that was never implemented. We are requesting to vacate this order. As previously mentioned, sections 35 and 36 have already been recognized as vacated by the board. The red is order 139, 134, creating 1280 acre drilling units, which only applies to sections 1 and 12 of 3 South, 1 West, and is operated by Oventive. The conversion in that DSU has already occurred as there is an existing producing long lateral horizontal well. The yellow and yellow hashed area is order 139, 158, creating 1280 acre DSUs for long lateral horizontal wells and 2560 acre drilling unit boundary well DSUs along the common sectional boundary in 3 South, 1 West.
Now turning your attention to what has been marked as Exhibit F, please explain to the board what this shows.
This plot reflects the new proposed 1280 DSUs and the reorientation and establishment of the requested DSUs to remedy the previous off-pattern DSUs and instead establish uniform DSUs for long lateral horizontal well development in 3 South, 1 East that were previously left out of the previous order 131, 151.
Now turning your attention to Exhibit G, please explain what this represents.
This illustrates the proposed internal 2560 acre units. They're the 9 internal requested overlapping 2560 drilling unit boundary well DSUs within 3 South, 1 East.
Now turning your attention to Exhibit H, please explain what this shows.
This reflects the 12 external requested overlapping 2560 acre drilling unit boundary well DSUs.
And now turning your attention to Exhibit I, please show or explain what this represents.
This illustrates all 21 overlapping 2560 acre drilling unit boundary well DSUs and is essentially just a combination of exhibits G and H.
Now turning your attention to Exhibit J, please explain what this shows.
This plot reflects all the existing wells in the subject area. The vertical directionally drilled and short lateral horizontal wells do not present a correlative rights issue because order 131, 151 established overlapping drilling units for those wells. Therefore, the board should not be concerned. I will address the 4 existing long lateral horizontal wells in sections 20 and 29 in the next exhibit.
All right, turning to that next exhibit, Exhibit K, please explain what this represents.
This is showing the accepted 4 long lateral horizontal wells existing in section 20 and 29, producing on the off-pattern sections of the 2029 DSU that were created under the 131, 151 order by our predecessor Crescent Point. We plan to keep allocation for these wells on the existing DSU basis as to not unduly interfere with the existing rights. Only new wells drilled will be allocated on the proposed section 1720 and 2932 DSU basis.
Do your records reflect Mr. Adamson or Geo Opinion Inc. as owning any interest in these 2 sections?
No, they do not.
Right. Could you please outline for the board what is the current certification practices that CH4 implements when it's drilling wells that are either button hook back into the drilling unit or are off drilling unit surface locations?
Sure. CH4 Finley currently certifies to the division that the horizontal well bores will be cemented and cased to the productive intervals within the established setbacks. We also certify to the division that CH4 Finley has obtained all requisite surface and subsurface consents and authorization for off-drilling unit short horizontal lateral to drill through to drilling unit boundary when applicable. As required under the 131-151 order, CH4 Finley has requested the same process be adopted here as to the new DSUs.
All right, the division in its memorandum asked if CH4 would also self-certify that as to any drilling unit boundary well to be drilled, that it will certify that the two 1,280 acre drilling units comprising that 2560 drilling unit will each have a producing well upon them. Do you agree to that as well?
Yes, we agree to this request.
Okay. Turning our attention now to Exhibit L, would you please explain what this shows?
This is the plat reflecting the notification area where notice was provided. All production interest owners are in red and yellow dashed areas. All working interest owners, including unleased owners, are within the black dashed area due to the setback reduction request.
All right, I'm going to refer you now to the original and several supplemental certificates of mailing that are pleadings already on file in this matter that my office prepared. Do you have those in front of you?
Yes, sir.
Do you recognize the names and addresses on those documents?
Yes, sir.
And who are those parties?
All governmental agencies having mineral jurisdiction.
And are they all the parties that you reflect on Exhibit L that you previously testified to?
Yes, sir.
And how were those names and addresses compiled?
They were compiled from CH4 Finley, Utah's internal land records, including title opinions, paid X, search of the BIA, DITLA, and UNA County records prior to filing the RA by internal staff with assistance of our contracted land service company.
Mr. Chairman, that concludes my examination of Ms. Womack.
Thank you. Ms. Souza, would you like to question this attorney or have someone from the division question this? I'm sorry, not attorney, this witness.
I do not have any questions for Mrs. Womack. Mr. Doucette, do you happen to have any questions for Ms. Womack?
No questions for me.
Thank you, Chairman.
Thank you. Board members, do you have questions of this witness? Hearing none. Mr. Moon, I don't see you up on the board, so I'm sorry if I missed you. Do you have a question for the witness?
No, no questions.
Thank you. I'll turn the time back over to you, Mr. McDonald.
Thank you, Mr. Chairman. I can start my examination of Mr. Atkins. Mr. Atkins, would you please state your name and business address for the record?
Yeah, my name is Shay Atkins. The business address is 1308 Lake Street in Fort Worth, Texas.
And what is your current position?
My current position is geology manager for Finley Resources, as well as CH4 Finley, Utah, with responsibility over all assets in the state of Utah.
All right, I'm going to ask you to refer to what have been marked as exhibits M through T for purposes of this cause. Do you have those in front of you?
Yes, sir.
Were they prepared by you or CH4 personnel with your input and review?
Yes, they were.
And turning your attention now to Exhibit M, would you please explain to the board what this shows?
Exhibit M is a type log identifying the Lower Green River and Wasatch formations and the Brotherson 1-11-34, paying particular attention to the callouts for Upper Green River, Lower Green River, Wasatch, and Mesa Verde formations.
And this is the same definition and type log that was utilized in the 131-151 order?
Yes, sir, it is.
Okay, now turning your attention to Exhibit N as in Nancy. Please explain what this shows.
Exhibit N is a cross-section, an east-west cross-section across the application lands. You can see a locator map in the bottom left-hand corner going from west to east with the blue dashed line. The cross-section is a gamma ray and resistivity logs with call-outs on the left side for the upper and lower Green River formations and the Wasatch formation. On the right, you can see the current development model that CH4 Finley desires to execute, with horizontal development being focused on the Castle Peak, Uteland Butte, and Wasatch formations due to their uniformity and common source of supply, with vertical development focused on the shallower formations in the upper Green River, Garden Gulch, Douglas Creek formations due to the discontinuity in reservoir quality.
Now turning your attention to Exhibit O, please explain what this shows.
Exhibit O is a very similar cross-section in the north-south direction and exhibits the same continuity and common source of supply in the Castle Peak, Uteland Butte, and Wasatch formations, as well as showing some of the discontinuity and that tends to lead to vertical development in the shallower formations.
Now turning your attention to Exhibit P, would you please explain what this shows?
Exhibit P is a regional stress map with the application lands outlined in red. The blue arrows are data points from image logs and sonic logs, whereas the purple arrows are data points from microseismic data that CH4 Finley has on wells that we currently operate. You can see the trend is a general east-west direction with the average fracture orientation from all these data points being north 85 degrees west. So essentially due east-west.
And this justifies the idea of the stand-up drilling units?
That's correct.
Turning your attention now to Exhibit Q, would you please explain what this represents?
Yeah, so Exhibit Q dives into the actual data, the microseismic data that CH4 Finley has related to the application lands. You can see there's 6 gold stars, 3 on the left side of the application lands and 3 on the right, creating a bookend effect of data around the application lands. The chart across the top breaks these 2 areas out to Area 1 and Area 2 and shows, you can see the average fracture half length based on this data. So Area 1 has an average fracture half length for microseismic data of 252 feet, whereas Area 2 has an average fracture half length of 239 feet. And it's the belief and the practice for CH4 Finley that you're not effectively draining the rock that is outside of the fracture half length. And so we give a lot of weight and a lot of credit to this data as far as determining our drainage patterns. And so focusing in on this 252-foot length, we're going to carry that number forward into the next few slides.
All right, turning to the next exhibit.
And so taking the last 2 slides, the 252-foot fracture half length, as well as the 85-degree orientation from the fracture orientation presented, you can see the current well spacing should be on R, right?
Yeah, I'm sorry, I went ahead. There you go. This is Exhibit R.
There you go. You can see the current spacing across the application lands with 560-foot east-west setbacks, as well as 330-foot north-south setbacks. And so based on this geometry from the microseismic data and the stress orientation, you can see there's 308 feet of hydrocarbon that's not touched with a fracture in the north-south direction, and 309 feet that's not touched in the east-west direction. And so we view these as unrecovered hydrocarbons if you drill a well exactly on those setbacks.
All right, now turning to Exhibit S, please explain what this shows.
And so taking these same geometries and applying it to the requested reduced setbacks in the north-south direction to 100 feet. And you can see a little diagram in the upper right that illustrates this calculation as well. Shows that at 100-foot setbacks, you still have a 78-foot buffer before the section line or the drilling unit boundary line to the north and south. So we feel like this is a safe and effective way to prevent waste and protect correlative rights and also recover as much resource as possible.
And turning your attention now to Exhibit T, please explain what this shows.
Yeah, Exhibit T is applying the same geometry and the same data in the east-west direction and taking the 560-foot current setbacks and reducing it to 330 feet. So utilizing 251 feet in the east-west direction from the presented data, increases your recovery and still yields a 79-foot quote unquote buffer zone relative rights issue. And so it effectively is a much more efficient.
I'm sorry, some of that got cut out by some background noise. You still yield a 79-foot quote unquote buffer zone, and then I didn't hear anymore.
And so it illustrates a much more effective way to recover the resource without leaving anything behind.
All right, so in your expert opinion, does the Lower Green River Wasatch constitute one common source of supply?
Yes, it does.
And that uniformity of the Lower Green River Wasatch members through the area make it a attractive area for long lateral and horizontal well development?
Yes, it does.
And finally, is it your expert opinion that actual data supports the reduction of the setbacks to recover additional resource without adversely affecting adjacent lands?
Yes.
Mr. Chairman, that concludes my examination of Mr. Atkins.
Thank you. Ms. Souza?
I don't have questions for Mr. Atkins. Mr. Doucette, do you have questions for Mr. Atkins?
Yeah, I've got, I think, one question.
Please.
Okay, yeah, Dustin Doucette for the division. If you could turn to Exhibit Q, please. So on this microseismic data that you ran and the fracture half-length information you gathered from that, what formations did that information come from?
It's actually across multiple formations comprising the Castle Peak, the Uteland Butte, and the Wasatch. So all of our horizontal target intervals are accounted for in this data.
Okay, thank you. No further questions.
Thank you. Board members, do you have questions for this witness? Mr. Brown?
My question is actually for Dustin. Dustin, have you actually seen the microseismic data? Is that something the division has been able to review?
Yeah, we've seen some of the representations of the microseismic data in some of those exhibits that Fred had talked about that were submitted via the GRAMA protected status.
Okay, thank you.
Any other questions, Mr. Moon?
Yeah, so reducing the setback, the east-west setback to 330. So internally, you're consistent there, but looking further out into the future, you're bumping on the east and west up against 560 space or 560 setback lands. So down the road, when there's a lease line well that needs to happen there, how would you do allocation where you have your closest well different distances from that lease line? I know that's looking way out in the future, but it's something we need to be thinking about. And I like the fact this is a large area that we're requesting a reduced setback, but not all applications have been that way, and we're going to have some inconsistency in the future when we go to do lease line wells between these request areas. So any thoughts about that?
Yeah, I think we're going to touch on some of your questions as we get into part of Kayleen's, Ms. Tovar's presentation. But in our opinion, we agree that it's the right thing to do is to do a little bit larger area. We have the test wells in this area and feel confident in the numbers that we're presenting and the full quote unquote cube development that we see these lands could be developed. Much of the offset lands we operate. And so that will give us an opportunity to come request the spacing in those areas. And then the lands that we don't operate, we've requested the lease line, the DSU boundary wells in order to try to accommodate some of those situations as well, where it may already have been drilled in the offset DSU at 560 feet. So we think this, a combination of this request, and then also as we move to the east, future hearings will accommodate that.
Thank you. Thank you. Yeah, it's just as long as you're thinking about that future, bumping up against different setbacks and how you're going to allocate those. So thank you.
We are, and I guess one other thing to add, I think in general, we're trying to approach this as in a long-term, holistic view as well, to try to do the same thing that you're doing and try to think ahead and have some foresight on some of those issues. So we appreciate the input.
Thank you.
Appears that there are no further questions from the board for this witness. So, Mr. McDonald, if you'd like to proceed.
Thank you, Mr. Chairman. I'll start my examination of Ms. Tovar. Ms. Tovar, would you please state your name and business address for the record?
Kayleen Tovar, 5128 Apache Plume Road, Suite 300, Fort Worth, Texas, 76109.
And what is your current position with CH4?
I'm currently the senior reservoir engineer responsible for all of CH4 Finley's Utah assets.
All right, would you please provide a very brief outline regarding your education, work experience, particularly with any horizontal well development in analogous basins, and any certifications, license, or publications that you may have obtained or done?
Yes, so I am a petroleum engineering graduate from the University of Oklahoma in 2008. I've been in the oil and gas industry since 2005, working through internships and other things. I started my career working in the Uinta Basin with Dominion Exploration and Production, working gas wells, vertical gas wells. I worked in operations for a while in oil and gas at various places. And in 2012, I moved into solely reservoir engineering and was working with the Bass family that then became XTO ExxonMobil in the Delaware Basin, which is analogous in that it has stacked and cubed development. I have been, for the last almost decade, primarily focused on extended reach horizontal wells going as far as 3 miles, as well as almost 1,000 cube development wells, and focusing on completions and all of the things that make stack and spacing work in the Delaware Basin. I also have a law degree from Texas A&M University, and I've been a licensed member of the Texas Bar since 2017. And I have 2 published papers, 1 SPE paper, it published in 2008, and a recent publication from ExxonMobil on greenhouse gas emissions and crude oil and natural gas in the Delaware Basin.
Mr. Chairman, with Ms. Tovar's resume and her testimony that she just gave, I would ask that she be recognized as an expert in reservoir engineering for purposes of this cause.
Division, any comment on that?
The division doesn't object.
Board members? Other than the fact that she's an attorney? No. I think that it is good for us to recognize her as an expert witness in this matter.
Thank you, Mr. Chairman. Ms. Tovar, I'm going to now refer you to what have been marked as exhibits U through X for purposes of this cause. Do you have those in front of you?
Yes.
And were they prepared by you or CH4 personnel with your input and review?
Yes.
Okay, turning now your attention to exhibit U. Would you please outline to the board what this represents and its importance to this matter?
Yes, this is original oil in place calculations of the 4 major Lower Green River Wasatch targets. We had these calculated by NewTek, a third party, to eliminate any bias in the calculations. And we've utilized these original oil in place calculations in the rest of our analysis going forward, including our economic analysis, which will be addressed also.
And as far as that goes, these numbers were used for the proprietary calculations that you used that we're claiming is protected under GRAMA. Is that correct?
Correct.
Turning your attention now to exhibit V. Please explain the significance of this exhibit.
So this exhibit is kind of an illustration of what potential future development could look like. We have step out wells that have already been drilled in this area and are producing, and we are ready for, as Shay stated earlier, to go ahead and develop this large area. Capital is what it is, so we will do the best we can to develop it in a manner that will recover the maximum amount of resources. We are requesting 12 wells currently, and up to 6 wells per drilling boundary unit line. So we anticipate, though, that if this is successful, we will request additional authorization to drill additional wells. So the 6 wells shown in red, 4 wells shown in yellow, and 2 wells shown in green in this exhibit are the 12 wells that we are requesting currently.
All right, can you explain the asterisk mark down at the bottom?
Yes. Yeah. Yes. This exhibit reflects that the full development on 880-foot spacing between the wells. This also will reflect as an example of why up to 6 drilling unit boundary wells may be necessary if reduced setbacks may result in less than those 6 wells. Uniformity of the DSU results in both infrastructure and economic efficiencies, and what that means is that we will be able to do pad development here, creating a smaller footprint, and be able to utilize facilities that would mean less facilities, less emissions, less greenhouse gases. So this also has many benefits from the surface side and the subsurface mineral side.
All right, and I believe what you said, correct me if I'm wrong, is that currently you're asking for 12 wells, but depending on the success of the project, you may be coming back for the board for authorization of additional wells.
That's correct.
All right. Now turning your attention to Exhibit W, would you please explain its significance?
So expanding on the other exhibits, we will drill about 430 feet from the east-west boundary line to allow for wellbore drift, since that 330 line would be a hard line. We just want to put this in here to show this as an example that there would be actually a true buffer of 860 feet between wells on either side. And it also is justification for drilling unit boundary wells because of that buffer.
Now turning your attention to Exhibit X, please explain what this represents.
This exhibit shows well economics that clearly favor drilling unit boundary wells and the requested 100-foot setback and 330 setback reductions. So here you can see that if we can get that 100-foot setback, you would be adding a completion stage basically. So 460 feet to your completed reservoir. We estimate that would be 36,800 additional barrels of oil per well, which is a 6% increase in production. This production is not linear to capital, so it's only about a 0.5% increase in capital per well, so very economic to do. That would account for, at $55 per barrel, around $2 million of revenue per well. This would be applied, since it's such a large area of development, to 193 additional long lateral wells. But the 330 setback spacing could potentially allow up to 2 more wells per bench in this, adding to that 193 number. This illustration down at the bottom is on 660-foot spacing, which some other operators in the basin are testing right now. Again, everyone is still trying to determine in several basins what is the appropriate amount of stacking and spacing between wells. So as we learn more with the 12 that we are planning to drill, this will become more defined and will just set us up for what we would potentially come back and ask for. I do want to note on the MPV on the bottom is that you will, no matter if you drill too many wells, you will recover more resource. The only risk to drilling too many wells is on the operator themselves on capital spend.
All right, would you address how the 330-foot inner well setbacks from the existing wells in section 20 and 29 will prevent communication? Is that your opinion?
That is my opinion. We would be able to appropriately space things. It would give some latitude in there to appropriately space wells and prevent waste and protect all correlative rights on any side.
So in other words, there shouldn't be any adverse impact to maintaining the existing production allocation and rights to those existing wells in that offset drilling unit. Is that correct?
Correct.
Okay. Can you also address about the potential for interference with the existing vertical wells that appear? There's quite a few in like section 34 and section 17. How will this development impact or potentially impact those wells, if at all?
They won't impact those wells at all. Those wells are all at shallower depths. They stop and are completed at shallower depths than any of the wells in our current horizontal development plan.
All right, so then is it your expert opinion that the reduction of setbacks and the drilling of up to 6 drilling unit boundary wells are necessary to recover additional resource that would otherwise be left in the ground?
Yes.
And is it also your expert opinion that this reduction of setbacks and the drilling of those drilling unit boundary wells will allow for greater recovery of natural resources with associated greater economic benefit and without adverse impact on adjacent correlative rights?
Yes.
All right, Mr. Chairman, that concludes my examination of Ms. Tovar.
Thank you. Ms. Souza?
I have no questions for Ms. Tovar. Mr. Doucette, do you have questions for Ms. Tovar?
No, I don't have any questions. Thank you.
Thank you, Chair.
Board members, questions for this witness? Mr. Church?
Yes. Ms. Tovar, on Exhibit V, where you've given us a horizontal full cube development example, you say you've permitted those 12 wells. Is this just an example, or is that your initial plan to work on this spacing?
This is just an example. We have not. I'll defer to Shay on that. I don't believe we've permitted.
We have not permitted pending the outcome of this hearing.
Right.
And so our plan is to begin permitting upon approval of this RAA.
Okay, just in this example, just a matter of curiosity, half of the wells in this example you look to initially go after are in the Uteland Butte. Do you have expectation for the Uteland Butte to be more productive than these other zones?
Currently, the Uteland Butte is our primary target, our primary tier 1 target, but we're also exploiting the other zones as well. And like Kayleen mentioned, we're capital restrained at some times, and so we're planning for the most efficient way that we can do to work across this acreage.
And I'll say that in my opinion, the Uteland Butte is also the zone that does not have 2 landing targets, and 2 landing targets are important to figure out before you develop. So with Castle Peak and Lower Castle Peak and the 2 Wasatch landing targets, we really want to preserve that for more study around the basin before fully developing that and potentially spacing it correctly.
Okay, and so the economics you've shown on what your well expectations are is an average of what you expect all of these zones, an average from all of these zones and not just your most prospective zone.
Correct. It's a average type curve for all of them.
That's correct. And to add to that too, we have drilled wells in all of these target intervals as well.
In this area.
Yes, that's correct.
Okay, thank you.
sorry to single you out, Mr. Moon, because I can't see you on the screen. Just want to make sure if you have a question or not.
No, I'm good.
Okay, thank you. Seeing and hearing no other questions from the board members for this witness, I'll turn the time back over to you, Mr. McDonald.
Thank you, Mr. Chairman. That concludes our presentation in chief. At this time, I would move for admission of exhibits A through X inclusive.
They're so admitted.
And finally, I'd just like to reserve a little time if necessary to respond to the division's presentation.
Okay. We will turn the time over then to the division and Ms. Sousa.
Thank you, Chairman Hansen. The division would like to begin first by expressing appreciation for CH4's willingness to acquiesce in our request for them to supply a verified statement that any drilling unit, boundary well APD, lists which of the two underlying overlapping 1280s are held by production and the wells that are holding those by production. Additionally, as it was mentioned before, we'd like to let the board know that we are in receipt of additional information that was submitted by CH4 and was stamped as confidential under GRAMA, the Government Records Access and Management Act. As the division has done in prior unrelated cases, the division would like to express that it believes this information should be public and should be before the board. But despite its beliefs, the division has nonetheless reviewed some data and has had the opportunity to ask questions. However, the division continues to have concerns. And to explain these concerns, I would ask that Mr. Doucette be sworn as a witness.
Michelle, could you swear in Mr. Doucette?
Will you raise your right hand, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Mr. Doucette, will you state your name and title for the record?
Yeah, Dustin Doucette, petroleum engineer for the Division of Oil, Gas, and Mining.
So the division submitted a staff memorandum in this cause. Did you either prepare that staff memo or was it prepared with your input and review?
Yes, I was involved in the review, content, and preparation of the division staff memo.
And what evidence specifically does the staff memo identify as required in order for the division to support reducing setbacks from 330 feet to 100 feet?
In the division memo, we'd asked that information or resources be provided to the division that we could do analysis and comprehensively look at the evidence and review it and make sure that we agreed with the recommendation. Some of the specific information that we asked for was reservoir property data, such as porosity, permeability, also fluid attributes, such as viscosity, compressibility, and also information on the fracture orientation and simulated reservoir volume, and some explanation or exhibits that would show how that all showed how that reduced setback was not going to have a negative effect on correlative rights and pressure drawdown through time on the offsetting drilling units or offsetting boundary lines. In general, that was the information we requested in the memo.
And did CH4 provide you with that data?
I mean, although they did provide much of that data, such as some porosity and permeability data, fracture orientation data, we did not receive, all the fluid attribute data, such as viscosity, compressibility, and some of the, fracture dimension data. One of the big concerns was that minor axis drainage radius and where that came from, and also how that through time, how that pressure drawdown would affect the reservoir and encroach on, offsetting units. So that was probably the biggest concern we had, our biggest concerns.
CH4 presented to the board some microseismic data at this hearing. In your opinion, is the microseismic data that they submitted and presented here sufficient to fully determine drainage patterns?
No, and I think as we stated in our memo, that's one piece of information. It does give us some valuable information, but does not necessarily tell how that reservoir is actually going to perform and how corrosive rights are being protected off offsetting drilling units.
Okay, so based on the evidence that you've seen, both the confidential evidence as well as the evidence that was submitted here today and the testimony that you've heard, can the division support reducing the setback from 330 feet to 100 feet and feel confident that it is not going to be draining outside of that area?
At this time, I don't think we have the information, and we're unable to confirm that it would not drain past that those hard lines, section boundaries. So would not feel comfortable at this time reducing that setback.
So just to clarify, it's the division's recommendation that the setback should remain at 330 feet in this specific case.
At this given time, correct, based off the information and testimony we received today.
And thank you, Chairman. That concludes my examination of Mr. Doucette.
Mr. McDonald, if you'd like
Yeah,
to.
a couple cross questions.
Go ahead.
Mr. Doucette, are you saying that you want 330 on north-south? What about the east-west?
I mean, the east-west, I think our biggest concern is definitely the north-south, the heel-toe portion, because that is encroaching a lot closer than east-west. East-west 330. I mean, it probably not as concerned about the east-west setbacks, but we would still have some questions about it. We haven't been able to confirm whether that's totally an issue either, or not.
Do you admit that that there are other orders that have been entered by the board that the division supported for 100-foot setback reductions for north-south stand-up units in this area?
Yes, I am aware of that.
Okay. Is there anything that would be significantly different between those findings and the findings that have been presented here?
I mean, I can't say in particular whether it would or not. In those cases, they did provide additional information that we were able to duplicate. So in general, I mean, this is a different area. So even though closely related, I can't say with 100% confidence that it would be relevant here or not.
All right, that's all the questions I have for Mr. Doucette. Mr. Chairman, I would like to be able to redirect my witnesses too.
Okay. Before we do that, board members, do you have any questions for Mr. Doucette?
Chairman, may I just redirect one question really quickly?
Sure.
Mr. Doucette, just for additional clarification. So in those prior orders where the heel-toe setback has been reduced to 100 feet, you have seen more data that the division was able to review and verify than what you have seen in this case. Is that correct?
That is correct.
Thank you. Thank you, Chairman Henson.
Thank you. Questions, board members? Mr. Borden?
Yes, Mr. Doucette, is the data, and perhaps somebody else needs to answer this, is the data that you desire to see not available, or is it considered commercially sensitive such that it hasn't been shared with you?
I think that's probably a question for the petitioner. I can't answer that.
Okay. Any other questions from board members? Again, I'm sorry to single you out, Mr. Moon, but do you have a question?
No.
Well, I'll be interested to find out what the answer is to Mr. Borden's question. So I'll turn the time back over to Mr. McDonald.
Thank you, Mr. Chairman. Ms. Tovar and Mr. Atkins, you're still under oath. You've heard Mr. Doucette's response. Would you care to respond to his statements?
I would. I have a question. Also, I'd like to confirm that Mr. Doucette and the division received some of the additional information, the additional confidential information that we filed post having a confidential meeting with the team to review some of the technical, or most all of the technical information that's been requested. Just like to confirm that they received all that data, the additional data. Some of this data was submitted as late as this week per multiple conversations regarding these questions.
I can confirm that we received data last Tuesday, the 20th, and again Monday afternoon. Or maybe it was yesterday.
Yeah, I think it was yesterday, the 27th.
Okay. So much of that, and Ms. Tovar can speak to that, but much of that data was surrounded around volumetric calculations related to the microseismic data and the other data that we filed and reviewed in support that all the volumetrics account for recovery within those stimulation and those fracture boundaries, showing that there is no that if you produce the reserves within the parameters that we've outlined in this hearing, as well as the parameters outlined in the confidential data, that you can recover the reserves that we expect to see and have seen in all of the wells that we have drilled. I'd also like to point out that we've supplied more data and confidentiality for this RAA than we have in previous RAAs that are approved for 100-foot heel toe setbacks inside of the current application lands and adjacent to just to the west. Ms. Tovar, you have anything to add?
I'll just add, I just wanted to make sure that the one you received yesterday after conversations was received and reviewed, because I think there was some misunderstanding on some parts, but after very lengthy conversations, I think we came to an agreement on that.
And yes, a lot of that data is sensitive, commercially sensitive, to answer that question.
Yeah, to protect competitive advantage.
Correct.
We're doing something that hasn't been done in the basin yet.
All right, thank you. Mr. Chairman, I'll turn it back to you.
Thank you. I just want to make sure I have a clear understanding of what was just discussed. There was additional information that was forwarded to the division last week and earlier this week. Has the division had an opportunity to evaluate that information, and would it have changed your position as to your recommendation on this matter?
So the division has reviewed that data, and some of that included the information that was identified in the technical memorandum. So they did provide us with some information on the reservoir properties, which is similar to what we requested, but they did not provide any information on fluid attributes like viscosity and compressibility or fracture dimension data. So it was incomplete, and because it was incomplete, that is why we were not able to verify that it was sufficient to give us the comfort that correlative rights will be protected. I'm sorry, I guess Dustin probably should have answered that question. My apologies. Dustin, do you have anything to add? You're a better person to answer that than me. And more appropriate.
I think you hit that nail on the head of kind of where we're at on that. We're still lacking information. Although I haven't had a ton of time to review the data. We have reviewed the data internally here and believe we are still lacking that information to confirm whether that setback is adequate or not.
And the statement that was made by one of the witnesses that they've reduced the setbacks on some of these wells within the area that's already been approved. I'm not saying that exactly right. They're saying that what they're asking for has already been approved in nearby drilling units. Is that assumption correct?
Is that a question to me, Chairman?
That is.
Sure, who that's a question for?
Well, okay. I guess I would ask that of the. I guess not of you, Mr. Doucette, but of the CH4.
That's correct.
And Mr. Doucette, even though they've provided this information for nearby other drilling units, you still feel fairly strongly that you need the additional information to provide a well thought out response and recommendation.
Yes, I believe so. We're basing our decision based off of what's presented in this case.
Okay, thank you. I appreciate that clarification, Mr. Brown.
Just so we can have this on the record, my notes reflect that Mr. Doucette asked a question earlier about whether the microseismic data came from across specific formations or one formation in general. And later on, I asked Mr. Doucette if he had reviewed the seismic data, microseismic data. I found it curious that he would have asked that question if he reviewed the data. So my question to you, Dustin, is that some of the information you found critical that was lacking in what was sent to you? Thank you.
No, I don't think that was necessarily lacking data. I think the microseismic data did kind of represent that. I think I was asking the question to get it on, maybe that portion on the record and clarify that exhibit. So it was kind of clarification of that exhibit. But I don't think our deficiency or our concern was necessarily with the microseismic. I think the microseismic did determine orientation of the fractures, which was definitely a portion of the evaluation process. But we were still missing some other critical data that is outside of the microseismic arena.
Thank you for that clarification.
Mr. Moon, I see you now. You can, I don't have to single you out.
Yeah, question for Dustin. So is your concern with perhaps the half lengths being larger or the orientation being more north-south? Because the most compelling slide to me justifying the 100-foot hill-toe setback is Exhibit S, which has the orientation pretty much going east and west. And so, but I don't know if it's that way across this whole request area or not. But that's quite compelling. So even if you have a longer fracture half length, you're still not getting close to the 100-foot setback. But they say here it's an average, so maybe it's a question for C.H. Finley also. Well, first, Dustin, what is it creating your concern, given the fact that you got pretty good buffer there?
Yeah, it's not necessarily, at the end of that fracture, it's the drainage area, and kind of like I mentioned, the minimum drainage radius is what we're probably more concerned with. So similar to maybe like a vertical well, if you were going to place a vertical well 100 feet from a section line, would you have an issue with, approving that type of situation? So it's kind of that radial drainage radius along that fracture path, I guess, is where the concern is. Not really necessarily at the fracture tip, but how what is that actual fracture radius, minimum radius there, and will that go across that boundary line? Because through time, and then how will that go? What's the time frame for that happening? Because eventually, if you produce long enough, more than likely you're going to have some effect. What effect is that on the offsetting unit or the offsetting section minerals, and how long does it take to get there? Is it 3? Is it 5 years? And is it minimal, pressure drop and minimal fluid movement? Those are the questions we still have, and I don't think we've got answers to those questions.
Okay. And just one kind of follow-up question. You had further concerns after receiving additional data. Did you let them know that, or was the time frame just not there for them to respond again before this hearing?
They've been very good getting back with us when we've told them we still had concerns. So they did submit additional information yesterday, and they did meet with one of our engineers yesterday as well and discuss. But in my discussions with him and my review this morning of the information, we still have those concerns that were not remedied, I guess.
Okay. Just one more. So if we were to, considering the division, where the division's at with this, what would you suggest we do? Adjust the setback to some different number, or what? And maybe I'm too early in asking for that recommendation, but.
I mean, I think it's already approved at 330. So I think our recommendation was that it should remain at 330 at this point until we get, further verification and further information to provide that verification.
Okay, thank you.
Mr. Borden.
Sorry, one more question for Mr. Doucette. We've heard a lot of these discussions on setbacks over the years, and it seems like we normally just get presented on fracture half-length data from microseismic and fracture orientation and stress field orientation. I'm not familiar, or perhaps I've forgotten the importance of fluid attributes. I don't remember that being presented very often for these sorts of things. Am I mistaken?
I think in a lot of the cases where there were some reductions from 660 to 560, yeah, we probably didn't. We did not maybe push that issue on that, but where we're going to 100 feet really near, we have written several memos where we've asked for this very information going back, I don't know, probably 6 or 9 months ago. We've had several of these that we've requested that information. And some of the information I think that Mr. McDonald had referenced on the offsetting units were a result of us requesting that information that had some of this additional information.
Thank you.
Mm-hmm.
Any other questions from the board members? Hearing and seeing none, this is an interesting problem. Ms. Davis?
You've said that the average fracture orientation is 85 degrees. What is that from and to? Am I missing that somewhere? mean, that's the average number. What is it from and to? In other words, this has a 252 foot fracture half length. I mean, it's clear that if it was straight up and down instead of at 85 degrees, you'd be hitting that borderline. What's the, not average, but what are the measured average fracture orientations? Do you know that?
Is that for CH4 Finley? Is that a question for CH4 Finley?
Yes, that's a question for CH4 Finley. Thank you.
Yes, so slide P, exhibit P, will address that orientation or expand on that orientation. And so this is north, the average is 85 degrees, north 85 west. And so all these, you can see the purple numbers are microseismic data points. The blue arrows are image log and dipole sonic log data points. And so that would be north 85 degrees west.
Yeah. And exhibit Q has all of those stars, kind of gives you a range of half length. And I'll just point out that the 252 is the more conservative average than the 239. So that's where that came from.
And to follow up as well, and this was something that was stated in in the confidential data, but due to the extremely low permeability of this rock, it's CH4 Finley's belief that we're not effectively draining reserves outside of that rock, which is not touched with a fracture, and so therefore anything outside of this fracture data, this induced fracture, would not be effectively drained. And so that's the basis of our testimony here, as well as the confidential data with the division, and also the reserve calculations of wells that we've drilled support this data to show that to reach the ultimate recovery of the wells that we have drilled, the only reserves that you need to touch in order to do that are those within the defined fracture stimulated reservoir volume, and that reserves outside of that stimulated reservoir volume from the induced fractures do not need to be accessed in order to meet the actual production data that we are seeing from our wells.
Right. And to reiterate on that, on equations that were provided in the confidential data, the only place where fluid attributes, and where I'll talk about fluid attributes, we do not have PVT data here to provide those fluid attributes in this particular area that I felt comfortable saying 100% for this area. But in known equations, fluid attributes are not used in anything but reservoir models, and we have actual data that supports our position today.
Right.
From production from all of these zones, like we've said.
Right. And at the end of the day, we don't want to drain across the lease because we plan to drill the well that's on the other side of that lease. And so we don't want to affect the quality of the additional wells that we want to drill. And so we want to optimize the drilling pattern in order to recover all the reserves without hindering the quality of the offset wells, because in this area we operate most of the offset acreage as well. So we would only be damaging ourselves from an operator standpoint.
I appreciate that you do not want to drain outside. If you look at Q, Project 2 has a 343 fracture half length, and Project 1 has 199. Which of those stars are Project 1 and Project 2?
That we're getting into the confidential portion of that data. I'll say there's this kind of the purpose. So if you have to see the yellow line for area 1 and the blue line for area 2. One is on each side of this area. The variation that you see there is stimulation design. We do not, the 343 foot half length was from our predecessor. We do not want to replicate that. We design and engineer our stimulations in order to stay within a tight area to increase recovery from that area, to touch as much rock as possible without reaching out very far. Our goal is not to reach out past 300 feet, 330 feet. That is not an effective way for us to produce that resource, because that decreases the number of wells that can be drilled and decreases the recovery of that resource. So if you go to some of the other confidential data, and maybe it would be good for this discussion, the recoveries here are fairly low, the recovery factors, for the amount of oil in place that we showed you earlier in this. And so we design and engineer our stimulations in order to effectively recover all of that data. We don't want to reach out a long ways. That's not a good data point that we want to replicate, but we provided it because it's a data point that we have, and it goes into the analysis for the best way to develop this resource.
Right. And specifically going back to, we don't believe that you will drain beyond your fracture here, given the permeability. Permeability was provided in confidential data, as well as our FCDs from the fracture.
Right.
Which is basically the porosity and conductivity that you create within the fracture, that we believe is 90% of your recovery. And the rest of that 10% won't even be hit till 30, 40 years out.
Right.
Any other questions, board members?
Just one more, Chairman Hansen.
Sure, go ahead.
And what you guys were just saying pretty much answered it. So that was a really good explanation you just gave. But Susan's question made me think of another question. So as far as the average half length, what is the kind of the maximum that you see fracs reaching in this area? I appreciate everything you said about, you really only want to reach out 250, 300 feet, because that's where all of your easy production is. But what is the maximum and minimum?
I would say that 252 to 255 range is our max. That's why we used it. We feel like that's a very conservative number for half length. As you can see, the other average was 239. Pretty confident that it's not going much past that. Definitely not past 300 if we can help it on our design.
I think our.
But when you say average, though, if your average is say 250, you got to have some reaching out quite a ways further.
Well, that's what I'm saying is we're using a very conservative average because we have legacy data here. So we're being conservative on using that 252. We didn't throw out what I'm saying is we did not throw out Crescent Point's data point. And we don't complete like they do, very, very differently, but we still included it in to be conservative on that number.
I think another thing it's a little bit outside of the realm of this hearing also, but our team has extensive microseismic analysis, completion design analysis in other basins for thousands and thousands of wells. As Kayleen mentioned, her experience in the Delaware Basin just to support that. And so taking all of the learnings for thousands of wells, 7 to 50 rigs running for one company, and applying that knowledge into this basin and confirming it with these 6 data points, and then saying we can take this design, we can tweak it a little bit to limit our fracture length to that 250 foot range, and then attempt to rubbleize all the rock that's within that range to maximize recovery of that rock. Effectively, if you have long lenticular fractures, all of your recovery is coming from those fractures, and you're missing the space in between those long lenticular fractures that's not being effectively recovered. So you can end up with stranded reserves alongside of a well that you drilled and completed. And so we want to minimize all. And so that's where just touching on, again, we're touching on confidential data and design and some of those things that we had reviewed with the division, but all those factors have been considered into our completion design and what's the best way to extract as much rock as possible without hurting ourselves and our neighbors. right? But at the end of the day, we operate most of the offset acreage this application land. So we don't want a detriment to ourselves either. And so we hope to be back in front of you in a few months asking for the same thing on those lands as well, once we have a chance to drill a few wells and step out and test those areas. So.
Okay, thank you.
Thank you for answering the questions. I guess this time, Mr. McDonald, do you have any further discussion?
Yeah, I do, Mr. Chairman. I want to address a couple things here. First of all, with all due respect to the division, my clients and myself have reached out to the division beginning a week after the exhibits were submitted. And to be left with the impression that things were handled and then get put in the hearing and hearing that they don't consider that, I don't think is appropriate. They acknowledge that my clients have reached out to them on several occasions. And to do this at the last minute is kind of a curveball that should not have occurred. Secondly, the board has recognized the importance of maintaining confidentiality in a lot of these areas. And it's already recognized that in prior precedent involved with other ones. So the data that is submitted, there is a good reason for it to be confidential. If you look on the screen here, you can see there's a lot of people participating from other companies as well, and that's the reason why. I also want to point out the fact that if necessary, I would ask the board take judicial notice of the testimony and exhibits that were submitted in cause number 600-01, which was CH4 Finley, where they requested 100-foot setbacks north-south, and it was granted. So this is not unprecedented. It seems to me it's totally inconsistent to say now that it's okay there in adjacent lands, but it isn't here, especially based on the data and the testimony that you have heard. Finally, and most importantly, notice was provided to everybody, and you don't see anybody else objecting to this setback issue as being of concern. So with that, I am of the opinion, and I would ask the board to consider the fact that adequate information has been provided. If necessary, I would ask the board to recognize that and take judicial notice of the technical information and exhibits that were provided in 600-01, which the board did grant the 100-foot setbacks of nearby lands, combined with all the data and the information that has been provided here. And we would ask that the request be approved in total. Thank you.
Thank you, Mr. McDonald. Ms. Souza, you have anything else you'd like to add to this discussion?
Sure. Just to sum up the division's position for the board. So the division has been in contact with CH4 on several occasions to discuss this confidential data. It's unfortunate that this isn't, this matter's not the only matter that we have before us today, and it's not the only piece of our job. And so if we were, not able to meet on their timeline, then, perhaps the confidential data should have just been provided at the same time as the exhibits, and we would have had plenty of time to review, and the board could have had plenty of time to review. The division's role is to review the data and provide a technical opinion. It is the division's technical opinion that the information provided to it is insufficient to comfortably say that correlative rights will not be affected. And so it is the division's technical opinion that the heel toe setback should remain at 330. And finally, as we noted in the staff memo and as supported by CH Finley, the division again just reiterates its request to the board that it include in its order the requirement for CH4 to supply a verified statement with any drilling unit boundary well APD, certifying that all lands within the two underlying overlap 1280s drilling acre units have been deemed held by production as to all acreage therein. This will enhance the ability of the division to administer the order, and that sums up my closing remarks. Thank you, Chairman Hansen.
Okay, thank you. Any other comments or questions? I think it's apparent that we're going to need to go into deliberations to discuss this matter. We'll go off the record and reconvene as soon as we've come to some sort of conclusion on this matter. Thank you. Michelle, are you prepared to go back on the record? Court reporter, are you there? Paul, is she showing up on your screens at all?
See it. Her connection is live. We're checking right now.
Okay, thank you.
Chairman Hansen, we are still reaching out via cell to our court reporter.
Okay, thank you. Just let me know.
Those emergency response vehicles were not associated with our court reporter.
Good to hear.
I'm back. I'm sorry. I just ran up to get a drink right at the wrong time.
Thank you, Michelle. We have good copy now.
Okay, thank you. Whenever you're ready, Paul.
And we are live. Recordings going.
All right, we'll go back on the record. We have Mr. Moon is in attendance electronically. The board has deliberated on this matter, and I believe a motion is in order.
Mr. Chair, I'd like to make a motion that the board grants the request as submitted with the exception to reducing the 330-foot north-south setbacks to 100 feet without the division's written approval. Upon the written recommendation from the division, the 100-foot north-south setbacks will go into effect. The division's written recommendation shall be submitted no later than August 23rd, 2021.
Is there a second?
Second.
Discussion on the motion? Hearing none, we'll take a vote. All those in favor say aye.
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 Thank you. The motion is passed unanimously. And I would assume it's appropriate at this time to ask Mr. McDonald if you'd prepare the order.
Yes, I will.
Thank you. Thank you for all the folks who participated and helped us work through this this matter. We will now move on to the next docketed item, after which I'll read into the record, and then we'll take a quick break. Docket number 2021-016, cause number 475-05, in the matter of the request for agency action of CH4 Finley Operating LLC for an order authorizing drilling of the proposed MB Tribal 29-42E H7UB well and MB Tribal 30N-42E H1UB well. This matter has been withdrawn. We'll take just a few minutes of a break. We'll be back in just 5 minutes, and we'll start on the next, the final docketed item of the day. So we'll go briefly off the record, Michelle, and come back. but we're ready to go live. I think anytime you are, Paul.
We are live.
All right. We'll go back on the record. The next and final docketed item on the agenda is docket number 2021-018, cause number 476-03. In the matter of the notice of agency action by the Board of Oil, Gas, and Mining, issuing an order to show cause to determine why David Sweat and/or Alberta Gas Company has not posted appropriate bonding or complied with other requirements for the oil and gas wells that are operating or have the purported ability to operate. At this time, I think we would take appearances of counsel if there are. If anybody's out there, I'm sorry I can't see you.
I'll start. This is Haley Souza for the Division of Oil, Gas, and Mining, and I have a historical background to provide at the very beginning after we've heard the rest of the appearances, if the board would still entertain.
We will do that. Just want to make sure we have Mr. Sweat or... Sorry, go ahead.
Sorry, this is David Slaughter representing Great American Insurance Company, wrapped up in this intrigue as surety on the NADK bond. I don't have anything to present, but I'm certainly interested and here.
Okay, thank you. Is Mr. Sweat on or represented?
I saw Mr. Sam's name.
We can't hear you, David. Or Daniel, I'm sorry.
I believe it's Mr. Sam.
Yeah, his dad's name was David.
He needs one more minute.
For those participating via telephone, *6 will unmute your phone. We're getting some crackling interference at this time. So if we need to mute your telephone link into the hybrid meeting, please do a *6 to unmute, regardless of the mute button on your iPhone, Android dialing platform of your choice.
Looks like we're still having a little bit of difficulty with Mr. Sam being able to connect in. We'll wait a few more minutes here.
All right. Can anybody hear me now?
We can hear you now.
Okay, had to try my laptop. I was having trouble apparently with my desktop. So this is Daniel Sam. I'm representing David Sweat and Alberta Gas.
Just a quick question, Mr. Sam. Is Mr. Sweat your client in attendance, or are you just representing his position?
I am representing his position. He is not in attendance.
Okay, thank you. Mr. Bigley?
Chairman Hansen, I just a bit of housekeeping. I just want to make sure that the record's clear that the order to show cause specifically issued by this board requested Mr. Sweat to appear before this board personally, and he is not here. So arguably it could be Mr. Sweat is in contempt of this court's order in the first instance. The second housekeeping item, now that we're on it, Mr. Sam, that their paragraph number 4 asked your client to produce the operative leases on the Alta fee wells in advance of this hearing. They have not been produced. Is that correct?
That's correct.
And they're public. Those are public records, correct?
That's my understanding, yes.
Is there a reason why they weren't produced to this board to satisfy the conditions of this order to show cause?
I'd have to have Mr. Sweat answer to that. That's all.
He's not here, correct?
He's not here.
So, Mr. Chairman, there's at least 2 conditions of the order to show cause that ultimately this board could hold Mr. Sweat in contempt for, just to start this proceeding forward.
Thank you for that clarification, Mr. Bigley. Why don't we at this time go ahead and Ms. Sousa, why don't you go ahead and provide the information that you volunteered to do so in the beginning?
Thank you, Chairman Hansen. So this overview starts in January, the last time we were here. If you remember, at that time, the board was considering the division's motion for an order requiring compliance. The basis of that motion was that Alberta Gas was operating the oil wells without complying with state statutes and regulations, including operating without a performance bond, among other violations. Pursuant to that hearing, the board issued an order requiring compliance on January 27, 2021. That order required Alberta Gas to immediately cease illegally operating the wells, to submit all past production and disposition reports, to submit evidence of payments to all royalty owners, and submit an accounting of all proceeds derived from the illegal operation of the Alta wells. Alberta Gas failed to comply with the board's January order requiring compliance. While Alberta Gas did cease operating the 2 fee wells, Alberta Gas failed to submit all production and disposition reports, failed to submit evidence of payment to all royalty owners, and failed to submit an accounting of all proceeds derived from the illegal operation of the Alta wells. In response to this failure, Board Counsel notified Alberta Gas of its failure through a notice of continuing noncompliance and board order and final opportunity to cure on February 24, 2021. Although Alberta Gas did submit some additional documentation in response to this notice, Alberta Gas still failed to submit all the documentation required under the board's January order. As a result, the board filed a motion to intervene in the case out of the 8th District Court in Vernal. The 8th District Court case was filed by Alberta Gas against the former operator, NADK, seeking to have ownership of the wells granted to Alberta Gas. A hearing was held shortly thereafter, and at that hearing, the board was granted leave to intervene. Also at that hearing, the court heard testimony regarding whether Alberta Gas should be authorized to operate the 2 fee wells and 5 federal wells pending the final disposition of the 8th District Court case. On March 22nd, 2021, the 8th District Court issued an order authorizing operation of wells, wherein the court authorized Alberta Gas to operate the wells subject to Mr. Sweat's representation that he would comply with the board order and with the state statutes and regulations regarding permitting and bonding. Following that order, Alberta Gas immediately began producing the wells again. despite not having bonding in place and despite not having yet complied with the board order. On April 15th, 2021, the board filed its complaint and intervention for violations of Utah's Oil and Gas Conservation Act, which asserted that Alberta Gas had failed to comply with the 8th District Court's order authorizing operation of wells, because Alberta Gas failed to comply with the board order, failed to comply with the state statutes and regulations, and continued to illegally operate at least 2 wells. The board requested a range of relief, including temporary and permanent injunctive relief, an order for full accounting from both NADK and Alberta Gas, and relief on statutory claims, including an order for a monetary judgment sufficient to fully compensate the adversely affected royalty owners, the seizure of product and proceeds derived from illegal oil and gas operations, and an order requiring parties to immediately cure the surface damage occurring as a result of their violations, among other requested relief. Neither Alberta Gas nor NADK responded to the board's complaint and intervention, and the 8th District Court has not issued an order on the complaint. The division has been inspecting the fee wells on a regular basis. The status of the 2 fee well sites has changed little since the January board order, and any changes noted have been substandard. At the wells, the division has noted oil covering the wellheads, cellars full of hydrocarbons, trash and debris littered around the location, and weed overgrowth exacerbating fire hazard potential, improper construction, including lacking liner and height requirements, and unlabeled chemical containers, which also lack spill containment. These are primarily violations of the rules on pollution and surface damage control and on fire hazards on the surface. Division inspectors have noted that these issues have been a continual problem during the Alberta Gas's history with these wells, and ensuring compliance does not appear to be a priority. Regarding the federal wells that Alberta Gas is seeking ownership of in the 8th District Court, BLM notified Alberta Gas of the need to increase its bonding on the federal wells on 2 occasions, but Alberta failed to comply with the increased bonding. On June 4, 2021, BLM notified Alberta Gas that it would cancel its leases if it did not receive the increased bonding. BLM has notified me that Alberta did recently post the required bonding for the federal wells. As such, Alberta has now has performance bonds on the federal wells, but has not posted any performance bonds with the division on the 2 fee wells. Alberta Gas remains in non-compliance with the board's January order. Specifically, Alberta has failed to provide a complete accounting. Reasonable and prudent operators use basic accounting principles to show credits, debits, and totals, demonstrating that they paid the correct royalty owners the correct amount, identifying the royalty owners that haven't been paid with any unpaid amounts deposited into a suspense account. Utah state statute requires that specific information be included with royalty checks to allow royalty owners to verify they are receiving the correct amount. But Alberta has failed to provide any of this information with the royalty checks he purportedly sent out earlier this year. Alberta also failed to provide any production and disposition reporting since December 2020 reports. The division knows that some of the wells were operational until May 6, 2021, but no disposition or production reports have ever been provided either to the division or to the division's council. Additionally, Alberta has continually failed to measure gas produced and has instead insisted the equipment on site is not capable of measuring produced gas. However, a division inspector has noted that in his prior career, he personally installed the equipment at that site, at the fee well sites, that allows for produced gas to be measured. Measuring produced gas is required for accurate production and disposition reporting. Regarding the production status of the wells, the fee wells were shut in following the January board order, but did produce for a number of days in March following the court's order authorizing Mr. Sweat to be the operator. As of today, the fee wells have been shut in, and it's the division's understanding the fee wells have been shut in since March when we ordered that they be shut in again. Alberta Gas has been producing at least 1 federal well on and off for many months. The federal well has been shut in since, to our knowledge, May 6th, but it's unclear how many months it was producing, since Mr. Sweat has failed to submit any production or disposition reports since his December 2020 report. Additionally, the division is unsure whether it is still shut in pursuant to an agreement with Alberta Gas's council because the division has not been able to inspect it recently. Given Mr. Sweat's recent events with bonding, it's plausible that Mr. Sweat has gone out and begun producing that well again. The division respectfully requests that Mr. Sweat testify as to whether he placed any of the federal wells back into production following his posting bond. But where Mr. Sweat didn't show up today, it's difficult for him to testify on that piece. So thank you, Chairman. That's the history that I provided since January. If you guys have any questions, I'm happy to try to answer them to the best of my ability.
Thank you, Ms. Souza. Board members, do you have questions for Ms. Souza? Doesn't appear that anyone here or that Mr. Moon has any questions. So at this point, I guess we would like to hear from you, Mr. Sam. If you can maybe answer some of the questions that Ms. Souza has asked about production and reporting, or just giving us an update. Tell us maybe why Mr. Sweat has not appeared.
I can
go ahead.
I can give a little bit of an update. I did forward the meeting link to Mr. Sweat. I imagine that he probably had already received it as well from the division. I can just give a bit of an update on what I know, which is certainly not complete. But Mr. Sweat has been under extreme financial pressure because of the obligation to get these wells up and running again. They are, as he views, valuable assets that are commercial and capable of production in commercial quantities. He was faced with a substantial bond increase from the BLM, from an amount which was around 25,000, I believe, for a statewide bond, up to 155,000. He was also faced with bonding increases on the state wells pursuant to state requirements from approximately $60,000 for both wells up to what was initially thought to be $120,000 and now up to closer to $185,000. He did meet the requirement, as Ms. Souza says, to bond the wells with BLM. And as far as he's concerned, he believes he's in good standing with BLM, of course, subject to the threat of the leases lapsing for failure to produce. I have not spoken with Mr. Sweat about production of any of the BLM wells, except for the fact that he is doing his best to remain in compliance, and that he also is doing his best to try to come into compliance with the bonding requirements of the state. I have reached out to Ms. Souza before, earlier in the spring, about the possibility of having Mr. Sweat bond the wells one at a time under the increased bonding requirement. He is capable of bonding one now, and he was then. I did reach out again to her, to Ms. Souza a week ago, and also informed her that he is still willing to do that and capable of bonding one of the wells with the other bond on the other well being made within 6 months. As to the reporting requirements, he has informed me that the BLM, as to the BLM wells, he has attempted or has been in communication with state officials to try to get himself and or Alberta Gas authorized as a operator with the state of Utah with respect to these wells, even as he is now authorized as an operator with BLM. He is having trouble, apparently. We had received communication from Ms. Souza initially that he was now authorized with the state of Utah with respect to these wells as an operator, but then subsequently that was withdrawn by Ms. Souza for some reason. But as far as Mr. Sweat is concerned, and then from what he knows, he always was the operator of record with BLM with respect to the BLM wells. That NADK, when they took over the wells, they did not properly bond those. They did not bond the wells, in fact, with the BLM, and in fact never did obtain authorization from the BLM to operate those wells. Yet the state of Utah authorized NADK as the operator of the BLM wells. Mr. Sweat's problem, as he views it, with getting himself authorized with the state of Utah is somewhat tied to the fact that NADK was authorized to operate the BLM wells without, in fact, being authorized by the BLM and without bonding the wells. So he is trying to get himself authorized with those wells with respect to the state of Utah so that he can get online and become a reporter of production with the state. I've informed him that he can report through me and indirectly and informally through Ms. Souza with production reports in the interim. And that's been my understanding that we can do it that way. But he has been trying to get himself authorized with the BLM or with the state of Utah on the BLM wells. So where we stand, he is in good standing with the BLM. He just needs to get himself on as an operator with the state of Utah with respect to 4 BLM wells. With the 2 state wells, we're still at somewhat of a roadblock, I suppose, with Mr. Sweat having the capability to bond 1 well with the extreme increase of bonding requirement, which would allow him to bond the other well within 6 months. That would have the benefit of releasing Great American, their obligation. It would also presumably open the wells back up, hopefully for production that would be a benefit to the royalty owners as well. Otherwise, if this is not allowed, Mr. Sweat is kind of at a loss as to how he can get these wells producing again. They, as far as he knows, the integrity is sound. He did do integrity tests on them within the last 2 years, and they are capable. They have the equipment and can be produced. As far as not complying with the order, again, I kind of wonder if we are being overly, I don't know if I'm saying this properly, but we have produced many pages of papers to the state over the last few months in an attempt to comply with the board's January order. And in every instance, we've been responded with emails that they are not sufficient. And they probably aren't. I'm not an accountant. Mr. Sweat's not an accountant. We've reported what we thought were all the production records. We've supplied checks, copies of checks to all royalty owners for all the production that's occurred since Mr. Sweat was operating the wells in the last year. He has, in fact, sent the checks. I'm not sure which ones have been returned, but he did so at the risk of not having done a full title search to make sure that royalty owners now are the same as the royalty owners were on the paydex back in 2016, which is the paydex that we're operating off from. So we've done we've taken a lot of steps towards trying to comply with that. We've taken a lot of steps with respect to securing title to the operating rights through the district court. And still we're not meeting the requirements 100%. And I don't know if this is in the best interest of the wells. They should be producing. They're capable of being produced. Mr. Sweat can properly report. It's probably not the best reporting system to have it go through me and then through Ms. Souza, but that's how it's been handled so far. If he were able to do it electronically on the state's reporting system, he'd probably be able to be in full compliance. But that's how I view the issues as they currently stand right now. We hope that the board would allow him the latitude to be able to bond these wells, even as he's able to under the extreme increase in bonding requirements, and by doing it one at a time, one now and one in 6 months at the latest, which he's able to do. And that's all I can say right now. If there are any questions, I'll try to answer those.
Ms. Souza, do you have any questions or responses you want to make at this time?
Yes, I do. Thank you. I'd first like to clarify the record that once the division was notified by BLM that Mr. Sweat had posted the bonding on the federal wells, the division did complete the change of operator on those wells. The communication that Mr. Sam is apparently referring to simply says that Mr. Sweat has failed to go online, click a link, and get login credentials so that he can now electronically submit the forms. He's capable of doing that at any time. We did not revoke his operatorship since we granted it to him last week. He needs to take ownership of him getting credentials. We can't get him credentials. He needs to do that for himself. But he does have credentials to one of the other reporting systems, ePermit, which would allow him to submit sundries and do everything else that he needs to do. He only is not able to submit reporting. Now that he has been granted operatorship for those federal wells, he is 100% responsible for doing that reporting online. He cannot submit it to Mr. Sam to have it routed through me and have our people manually enter the numbers for him. He is responsible for doing that himself. On several occasions, we've very specifically identified what a complete accounting is. That's where we see credits and debits and what portion is operating and what portion is royalty, goes to the royalty. We have never seen anything like that. And I think it's interesting that Mr. Sam now says that Mr. Sweat is not an accountant when he has told me on dozens of occasions in the past that Mr. Sweat is an accountant and he should know better. I do have access to one lease that was provided by the Bowdens many, many, many months ago. And it contains language that if, the well is shut in for a period of 12 months, then the lessee must provide payment to the lessors. They're looking at production reports. There are several times in the history of the 2 fee wells that the wells have been shut in for longer than 12 months. Mr. Sam, is it your, belief that Mr. Sweat provided the necessary payments during that time and that the leases are actually still valid?
I don't know what time period you're referring to. If it goes beyond the NADK's operatorship, prior to their operatorship, for the current last 2 years, Mr. Sweat has paid royalty owners for the 2020 production. There has been no production payments received for 2021. And if it goes to the end of the year, he is prepared to pay shut-in lease payments for 2021. As to prior years, David Sweat does not know what's happened with the wells during NADK's time period of operatorship. He's noted that they have reported production over periods of time where it didn't appear that there were shut-in periods more than a year. That's all that I can speak of with respect to that at this point.
Because I can see that representatives from the Bowden Trust are online, I would note that looking at the division's production history between 9/1/2013 and 7/1/2015, and also between 10/1/2015 and 11/1/2017. And this is being recorded on YouTube. So if the Bowden Trust needs to go back and relook at those dates, they can do that. I would suggest that they determine whether they receive payments, shut-in payments during those period of time, because that is when Mr. Sweat was the operator of these wells. And so I question whether the leases are valid. It seemed like I had one more comment, Chairman Hansen, and it has escaped me.
Well, we can always go back to it when it comes back to you. Board members, do you have questions you'd like to address to Mr. Sam? Hearing none, I guess I had just a comment that the division and I think the board have been very patient with Mr. Sweat since issuing the order. It feels like we're not making a lot of progress in being compliant with that order. Obviously, there's been some, but it appears that we're being strung along a little bit, I guess is the way to put it. I think at this point, if there are royalty owners that are online that have an interest in this matter, if they would like to make a comment at this time, unfortunately on my screen, I cannot see if there are folks here online, but if you have a comment you would like to make on this matter.
Yes, I do. This is
Betty
Lorraine.
Sorry. Go ahead.
Betty Lorraine Oliver on behalf of the Betty T. Bowden Trust. And I would just like to comment that, to my knowledge, we have never received a shut-in payment on these two wells from, I'm sorry, Crescent Point, who was the producer of record until NADK took over the leases. And I say that because the Betty T. Bowden Trust never, or Betty, or any of us ever knew that Mr. Sweat was the producer on these. He was not ever listed as the producer. And never provided a bond for him for all of the time that Crescent Point was actually handling the payments on his behalf. The last payment we received from Crescent Point was in April of 2019. And I think that for the between about 2016 to 2019, payments were very sporadic from Crescent Point. And basically that's as much information as I can provide today.
Ms. Souza, do you have any questions you wanted to ask Lorraine? No? Okay.
No, I do not. I remembered what my other thought was, though, when it's appropriate to come back around.
Okay. Board members, do you have any questions that you would like to ask Ms. Oliver? Hearing none. Haley, why don't you go ahead and bring up the point that you had forgotten to moments ago.
Mr. Sam has requested to me on two different occasions that Mr. Sweat and Alberta Gas be allowed to bond one well at a time. On both of those occasions, I have referred him to the board and said that is a decision that is outside of my pay grade. And for whatever reason, Mr. Sam still has not requested that of the board, but instead is continuing to put it on me that I've refused to grant that request. One question that I do have regarding that request that may assist the board in deciding whether or not that's a good idea operationally would be, are the mineral owners the same? And in full disclosure, I requested that Mr. Sam gather this information last week so that he could be prepared to speak on it today. I hope that he took the time to do that.
Yes, I can do that if the board would grant me to speak to that.
Sure. Let's have that discussion.
Yes, as to the pay decks on these two wells are almost identical. There is, and I did talk to Mr. Sweat about that. There is maybe one royalty owner that has a very a small sliver of a royalty interest in one well that they don't have in the other well. So it's probably, as David Sweat feels, it's probably 99% identical. Operating one well or getting one well started may have a very slight negative impact on one royalty owner to make them to have to wait 6 months for the bonding on that other well. That's the only impact it will have. And this is not unlike what goes on, I think, in the oil field all the time, where operators will improve one well over another one, or make decisions to drill on one property and wait to drill on another one. It's not, I don't think it's much of a matter of fairness in this case to allow operating one well now and another one 6 months down the road when bonding occurs. Again, I don't think that I blamed Ms. Souza for not granting David's request to bond these wells one at a time. We're making that request now of the board, if the board will entertain that request, that he be allowed to do that. That seems to be the only way that he'll be able to do it financially, given the increases in financial responsibility, both for the BLM wells and for these 2 state wells. I did have a lengthy discussion with the engineer regarding how it was derived at the current bonding amount on these 2 Alta wells and why they were increasing so much. And I understood, and I did receive a breakdown of costs. This is a full cost bond that's being proposed by the state on these wells. It wasn't full cost in the past, is my understanding, but now it is. And we did make our arguments that things were a little rich on those costs, that we thought that it was a little overcharged. With that, the engineer did agree, and I forgot his name, I apologize. He did agree to come down a little bit, but not nearly as much as we would hoped. And with that, it is a substantial financial burden to do this. But this is as we see it, the holdup in getting these produced. And the holdup also affects unfortunately, the royalty owners as well. So we're hoping, and we ask for the board's consideration of these this circumstance in giving Mr. Sweat a little more patience and a little more leeway to come forward and get these bonded and produced. And that's all.
I hear what you're asking, and we will discuss this, but I think that there are several issues that Mr. Sweat needs to come in compliance with. And they've been listed, I think, here today. And one of them is just to get proper reporting going above and beyond the bonding, but get signed up and provide the credentials so that he can start presenting the correct information on the website where he's required to report the information that we still haven't gotten. This is a very difficult ask that you're making, and you and Mr. Sweat are asking of the board to be patient on something that we think we've been very patient on. However, we will deliberate to have a discussion about this. Mr. Begley, is there any additional information that we should be asking for that we haven't gotten yet, or discussion that we need to have?
Thank you, Chairman Hansen. If you wouldn't mind, just for the record, I'd like to ask a couple questions to both the attorneys that have made an appearance.
Yes, please do.
Ms. Souza, is the division, have they inspected the wells to determine whether or not there's going to be any damage, or can they test to see if there's any damage to the mineral estate for these wells being held idle?
So I did ask about this and was told that it's generally recognized that restricting production or temporarily shutting in production can cause temporary or long-term loss of productivity, but that quantifying these risks with any level of confidence is difficult, if not impossible, because of the number of variables and their individual and compiled effect on production.
Okay, thank you. And then with respect to, you already identified the violations with the basic surface area, but is there any other major environmental, public health, safety concerns with these idle wells?
No. Just that the surface issues are the primary issues. We don't expect that a wider environmental problem could present itself.
Okay, thank you. And Mr. Sam, if I might ask you a couple questions too, just for the record and for the board's general understanding and appreciation so they can make an informed decision.
Sure.
Recognizing that this is your client's responsibility to comply with a court order, and this is an order from this board to submit leases that would indicate whether or not your client even has operation, if they can operate in this area. Certainly, you've testified today that you've went over many different aspects of your client's operations. Central to that would be whether or not they have valid leases. Can you represent to this board whether or not your client has valid leases to date on the Alta fee wells?
Well, no, we haven't done any title work on those. And I imagine, Ms. Souza raised some questions about maybe the possibility of more than a year of production lapses prior to 2016 that I'm not aware of and haven't been made aware of and haven't discussed with Mr. Sweat. That being said, I don't know if he made shut-in payments. It was in the hands of Summit Energy, not Crescent Point. Summit Energy was the one reporting on these wells through the last decade, basically, clear back to 2013. And I'm quite certain that it was their practice to pay shut-in payments if the wells were not produced. So I don't believe that there would be any, without any information except for my own gut feeling, I don't believe that would create any title problem with respect to the leases. But we haven't done a full-blown review of the title to be able to verify that.
Just as a follow-up, Mr. Sam, I don't think that you need a full-blown title opinion to determine whether or not a lease is valid.
Mm-hmm.
So you can review what the primary term is. All oil and gas leases need to be held by production. If they're not, there's continuing operation provisions, which also include shut-in royalty. And it's easy calculations of those leases. And we could have done that today if we would have had those leases as well. So the inference that is made is that they're probably not valid.
No, I'm not inferring that. It's just that I have not gone over that with Mr. Sweat. I have not, and not gone over the records with Summit Energy either. So I don't have the information that I could be able to make that determination.
Mr. Sam, would you agree with me that it'd be an important determination whether or not these are commercially viable wells for your client? That would be a first point of consideration. And due diligence is to make sure that you have valid leases.
Absolutely. I've been focused on the legal, not that end of the legal aspects of the leases. I've been dealing with the litigation and concerns regarding that. But I do agree that if we're fighting on one side, trying to get title cleared, on the other side, which we could be losing title if shut-in payments aren't being made. I understand that, but that's not been an area that I've been involved in.
Understood. And Chairman Hansen, I just have one follow-up question, if I may. And on that point, you did indicate, and I took a note, that you have made steps in what I believe to be in the proceeding against NADK venued at the 8th Judicial District to perfect some sort of title.
Go ahead. Sorry, go ahead.
And you just indicated that you're working on the title end, on the litigation end of that. But since this board's intervened, the record's clear that your client hasn't filed an answer or otherwise responded, as Ms. Souza said earlier, to the complaint and intervention. nor has there been any subsequent filings in that case. So I'm just curious what steps that you've made to perfect title, if you will, as against NADK in that proceeding.
In the last few months, I haven't filed anything with the court, but leading up to that, we have engaged in substantial litigation. We've been in, and I think I've also reported to this board in the past, the involvement we've had in the bankruptcy proceeding, in getting the automatic stay lifted on NADK's bankruptcy so that we could proceed in the litigation. In the last,
I'm sorry, Mr. Sam. I'm just talking about since the board had to intervene in that action. What steps have you taken?
We have not. Well, we're waiting. I'll tell you some of the discussions we've had has involved whether or not it commercially made sense for Mr. Sweat to proceed on the wells, on the state wells, given the financial responsibilities that he's had to come up with on the new bonding requirements. That's a big concern to him. He's determined that he would be able to do that if he can do it one at a time. Otherwise, he is just unable to do that. And in light of that, there may be not a point in proceeding in the litigation with respect to the two state wells. With respect to the BLM wells, of course, he's in good standing, and he wants to remain in good standing with respect to those wells. And but we have not responded with respect to the complaint in intervention yet.
Thank you, Mr. Sam. Chairman Hansen, that's all the questions I have. I did want to make sure that the board is well aware that to the extent that we've had any interactions and workings with Mr. Sam, he's been a consummate professional. He's been responsive. He's trying to do his level best. It's just in a challenging position with respect to his client.
Thank you. Appreciate that. Yes, Mr. Borden.
I perhaps should have asked some of these questions earlier, but I'm just trying to understand what has and hasn't been submitted to the division. Ms. Sousa, am I correct in remembering that you have not received any production records from these wells since last year?
We received production records up through December 2020. However, I know that there were periods of time during 2021 that Mr. Sweat produced both of the fee wells, specifically for at least a couple days in March. And he also produced the Federal 133 well, and we have not received production and disposition reports for either of those wells for any period in 2021. We have also not, in the board's original order, it demanded a complete accounting, and the purpose of that complete accounting is so that it can be determined the amount that is owed to royalty owners. We have not received anything resembling a complete accounting. Let me look back. There's something else that is missing still. Well, the last piece was evidence of payments to all royalty owners. Mr. Sweat did provide a list of checks that he supposedly sent out with some check marks on a old deck list, but it wasn't anything that the division considered sufficient to be able to make reasonable inferences from.
And you've requested the production for this year, have you not?
I'm pretty sure it's been requested on numerous occasions, either in phone calls or emails.
So this seems like one of the most basic and most important pieces of information that surely, Mr. Sam, you and your client or your client should have this information. I mean, he's been the one that's been producing them. How could this not have been provided to the division yet? Mr.
Well,
Sam.
Mr. Rowe, he has, he's ready to report on the federal well. I know it's just a matter of getting online and doing that. He has the information to do that with. And there's a little disconnect there. I guess he just needs to click a mouse. That's what I understand here. So I will let him know that that's all he needs to do. As to and that's as to the federal wells. As to the state wells, and now I personally am not aware that it was produced. I've submitted production records through January 17th, I think it was, when they were shut in. And then they were, according to Ms. Souza, opened up again for a couple of days in April. I have not received those production records for those couple of days yet from Mr. Sweat, but I will ask him to do that so that we can submit it. Nothing has been sold, I know that, in any tanks. So whatever was produced for the couple of days in April or March, it hasn't gone anywhere. It's still in the tank. So, but that doesn't mean that he doesn't need to report it. I understand that.
Yeah, it doesn't seem like it's rocket science. Wouldn't a simple Excel spreadsheet suffice to transfer this information that's been requested?
Yeah, I don't have an Excel spreadsheet that I'm using, but Mr. Sweat, he is an accountant. I have mentioned that before, but he's 67, somewhere in there, age-wise. He hasn't been acting as an accountant for decades. He's been an oil man for decades. So I'm not sure how, when I receive reports from him, they are on old-fashioned accounting spreadsheets, not Excel. And I haven't taken the time, or my office has taken the time to convert those to Excel spreadsheets.
Thank you.
I'd also note that the production and disposition reports we have received are inaccurate because it doesn't measure any of the gas produced, because Mr. Sweat has apparently decided that the equipment that exists out there doesn't exist out there. It may be broken and he may need to figure out how to replace it and get it up and running again, but it's capable of measuring the gas produced. So if he continues to refuse to fix that equipment and report on the gas produced, then we'll never have accurate production and disposition reports.
Mr. Sweat is not opposed to reporting it. He has just reported to me that it's not capable of reporting that information. And he's also gone through that with the BLM officials as well, which have indicated to him to report based on the minimum amounts that are needed to operate the wells. And that's how he has measured it himself, is that there is a minimal amount of gas produced, only sufficient to operate the well during the summer, but insufficient during the winter, as each of these wells are required to have propane propane used, shipped in order to run line heaters and whatnot, because the wells don't produce enough gas. None of them do to keep them operating during the winter. So that's what I've been told. That's all.
I have a quick question for Haley. My understanding of the electronic reporting system is it's fairly easy once you got your certificates that you can go on and report production and oil, gas, and also list payments. Is that correct?
That is my understanding. I'm not sure about the payment piece, but My understanding is it's not rocket science.
Okay. All right. Thank you.
And I would also like to note, since I have the production reporting ahead in front of me, that when Summit Operating was reporting on behalf of Mr. Sweat, they consistently reported substantially more MCF per month coming out of these wells than barrels of oil, substantially more than what would be required to operate. And that's all I have.
Okay. Mr. Brown?
Mr. Sams, I'm not as eloquent as my other board members here, but I just got to tell you how I feel right now. I feel like somebody's trying to beat me to death with a rubber noodle.
Okay.
Every time we ask a question, we get given some lame excuse why it's not done. I'm 67 years old, and I guarantee you I could do the math. And I'm not an accountant, I'm a geologist. I just don't understand why you haven't made it clear to your client that we are dead serious. And we want to know, I personally want to know why I should even give any credence or semblance to your request today to continue to allow this to continue. If this were at my sole discretion, this would cease immediately. It's not appropriate. And like I say, we're just getting the runaround. I don't like being pommeled like this. We've made it very clear in our writings. We've been very generous. We've done the best that we can. And we just get pommeled and pommeled and pommeled by the rubber noodle. Something has got to happen. I personally have no desire to continue this. It's a mockery of what we stand for in the state of Utah, to produce wells and to treat people fairly with royalties and to be responsible operators. You give this industry a bad name when someone operates this way. That's just the way I feel. I want it to be on the record, and I want you to know that. That's the way I'll be working from this going forward. Thank you, Mr. Chairman.
Thank you, Mr. Brown. Any other comments? Mr. Moon, sorry I lost you again. Do you have any questions or comments you'd like to make?
I would just second what Mr. Brown just stated. Thank you.
Thank you. Well, at this point, I think we've heard presentations from the state, from Mr. Sweat's attorney, Mr. Sam, and from the royalty owner. I think we need, as a board, to decide how we're going to treat this matter going forward. Perhaps at this time it's appropriate to deliberate and consider what we've heard. There's a request that we consider allowing these wells to operate one at a time until he can afford to post a bond, but I don't know that that's a request that we can consider at this time because it hasn't been made formally. I think what we need to deliberate on is what we need to do to go forward with how our original order will be implemented, and because of the lack of response I see from Mr. Sweat, that how the board is going to go forward and what we would like the division to do in this matter. Board members, would you like to deliberate and discuss this for a few minutes? I think we will go off the record, Michelle, and we'll be back shortly.
Chairman, we are back live and the recording is going.
Thank you. We'll go back on the record, Michelle. I think that I will make a motion on this matter. The board believes that there's been an inadequate showing of cause. I think, first of all, because Mr. Sweat, who was required to make a personal appearance, hasn't even bothered to show up. My motion is that for an order that Alberta or Mr. Sweat, within 30 days, fully bond both fee wells, comply with reporting requirements, produce lease documents for the wells, and comply with any other regulatory requirements that he's not currently complying with under the division regulations. And after 30 days, division will file a status report as to compliance with this order. If Alberta / Mr. Sweat has not complied, the division is to pursue penalties to the full extent of the law. And finally, the board council is directed to proceed with the board's complaint in the 8th District Court and any other contempt proceedings resulting from today's activities. Is there a second for that motion?
Mr. Chairman, I second the motion.
Discussion. Any discussion on this motion? Hearing none, we'll take a vote. All those in favor say aye.
Aye.
Any opposed? Hearing none, the motion is unanimous. I don't know that we have any other discussion in this matter, and there is no other docketed item before the board. So we will close this particular hearing and we'll reconvene in a month. Thank you for your attendance and your participation.
Thank you.